Hmm.
Yeah. I actually wasn't even walking out the standing, waiting on Ellie, watching the kids football. And I stepped back like this and I went, oh no. And they must have heard it. I didn't like scream or anything, but everybody turned and looked at me. Oh no. They heard my ankle. On the prosecutor's end. Okay. Let's get it. Miss Fitness Society ever provide? I don't believe so. I don't believe so because these that she left here, they would work. You know, the ones that she left. I told her that. Yeah. Yeah, no problem. But as far as I know. Okay. Miss Bailey, did you say that Thomas was not your case?
Thomas is mine.
It is? Okay. Do I have the parties on Thomas?
Yes,
Ready? Colleen's case number 2159046, the people of the state of Michigan versus Leroy Terrell Thomas. The defendant is charged with count 1, weapons, firearms, possession by felon. Count 2, assault with a dangerous weapon, felonious assault. Count 3, weapons, felony, firearm. Count 4, weapons, felony, firearm. Habitual offender, court defense notice. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P840009.
And good morning, Judge. Neighborhood Defender Service by Jackie Pilkowitz, P81653, on behalf of Mr. Leroy Thomas, who is present via Zoom and consents to proceeding via Zoom. Mr. Thomas, will you state your name for the judge, please?
Leroy Terrell Thomas.
Thank you. What is your pleasure, counsel? Today's the PCC. Do you have discovery?
I believe Ms. Bailey just sent the link over to me. So no, I was not in receipt of discovery until today. However, in light of the fact that she just sent it to me, we will be requesting an in-person examination at this time. Mr. Thomas is on a GPS tether. I am asking for the soonest possible court date. I know, of course, that can be very difficult, but I would like to just make that request known.
Thank you. Okay, there's a demand for this is a non-custodial situation. Unfortunately, you know where our dates are in terms of setting exams, but Madam Clerk, is there somewhere a closer date due to the fact that he is on tether?
October 7th at 11 a.m.
I have 2 other exams that morning. Is it possible to do a different day? I apologize, perhaps the next week.
Oh, you want the following? October 12th at 11 a.m.
That works.
Perfect. In-person exam, October 12th at 11 a.m. So, Mr. Thomas, please plan to be here at the courthouse, not on Zoom. And please make sure that you plan to arrive in advance of that time so that you're not delayed coming into the building. There will likely still be a screening process for which to enter the courthouse. And I don't want any delay to affect your ability to be here when the case is called. Are there any other concerns?
Yes, Judge, with regard to Mr. Thomas's tether, I would like to make a motion to modify the tether condition. Currently, I believe that he's restricted pretty much to house arrest other than going to and from work. I would ask for essentially a free roam tether at this time. There have been no hiccups to my knowledge since he's been out on tether for the last several weeks. Of course, the no contact order would remain in place, but in light of the fact that he could be on tether for the next few months, likely, I am asking for the court to lift that restriction.
I'm sorry, I'm trying to stop you without shouting. Thank you. Thank you for turning that fan off. Did you turn, is it off? Okay.
Yes, ma'am. I believe
Okay.
it's off or in the very least on a closed setting.
Okay. Ms. Pilkowitz, so sorry, but we're having, it's a little bit of a challenge sometimes from an auditory perspective. Could you repeat?
The last thing that I got is, to the best of my knowledge, the tether, the light has been untethered the last couple of weeks.
Could you, well, I was just going to ask you to repeat what your request was, just so we're all on the same page.
Yes, the request is just to lift any tether restrictions. Currently, I believe he's limited to go to and from work, and otherwise he's on house arrest. Given the fact that there have been no issues thus far and the length of time for which he will be likely on tether, I'm just asking the court to consider just a free roam tether at this time.
Madam Prosecutor. Now, as I look at this, you know what, Tammy?
Mm-hmm.
Could you see if there's a sooner date than October?
Okay,
I'm just seeing a couple of things that are causing me concern.
okay.
As I look at this though, Ms. Pilkowitz, this is the situation where not only are the allegations extremely assaultive, but it included a handgun. And your client is listed as an habitual offender, fourth offense notice. I'm honestly, I'm not real comfortable with altering the tether restrictions to the extent that the hourly restrictions are lifted, unless the prosecutor is going to acquiesce to that. But what I will do is provide you with an exam date that's much closer than October.
August 5th at 11:30.
That works for us, Judge.
Sorry, August 5th at 11:30?
Yes.
Okay.
New in-person exam date, August 5th at 11:30. Please disregard that earlier date given, Mr. Thomas, and we will see you then.
Thanks.
Thank you.
You're
All right.
welcome. Please make sure that you continue that no contact provision, Mr. Thomas, and abide by any restrictions as it relates to your tether, okay?
Yes, ma'am.
Thank you.
Do I have all parties on Joka and Putros?
Yes,
Madam Prosecutor, do you want me to call both cases or do you want me to call them separate?
I would prefer both as they're both co-defendants,
Okay.
just charged separately.
Okay, I'll call them both.
Wait, let me just take a moment to.
Okay.
Let me say good morning to everyone, and let me also stress that if there's anyone that's new to Zoom that is not familiar with how to work it in conjunction with your device, please take a moment and do so. Become familiarized with the settings. It is really important that everyone keep their microphone on mute. Keep your microphone silenced unless you are speaking. And even if your case is being called and you have a lot of background noise, I will need you to silence your microphone. Makes it very difficult from the courtroom perspective to hear what's going on. So please be mindful of that. Also, especially if you're new to Zoom court, but even if you're not, please know that this is tantamount to being in the courtroom. So my expectation is that you're going to conduct yourselves accordingly. That would include being properly clothed, wearing clothes, in fact, and making sure that you refrain from the use of any profanity or any other thing that you wouldn't do inside of a physical courtroom. In the event that I have to continually mute your microphone or anything of that nature, you may find yourself either bounced out of Zoom or in a waiting room. Also keep in mind that if there's any motions from either prosecution to defense or defense to prosecution, please make sure you have a side conversation with the opposing counsel so that we're not caught off guard having to stop and revisit the matter. If you shoot a text over to opposing counsel, giving a heads up so that we can move along efficiently, that would be much appreciated. Also, if your case is called, you're the defendant, or otherwise, please make sure that not only I can hear you when you put your name on the record, and I will need you to put your own name on the record, but I will also need your video running. I will need your video running. So please take a moment before your case is called, again, to familiarize yourself with the device that you happen to be Zooming with. Okay, thanks.
Calling parties on Joka, case number 2158248. The people of the state of Michigan versus John Salon Joka. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 3, weapons, firearms, possession by felon. Count 4, weapons carrying concealed. Count 5, weapons, dangerous weapon carrying with unlawful intent. Count 6, weapons, felony firearm. Second offense notice. Count 7 and 8, weapons, felony firearm. Second offense notice. Habitual offender. Fourth offense notice. Mandatory 25-year sentence. This matter is scheduled for a probable cause conference. Calling co-defendant, case number 2158727. The people of the state of Michigan versus Christine Putris. The defendant is charged with count 1, accessory after the fact to a felony. Count 2, weapons carrying concealed. Count 3, weapons, felony firearm. This matter is also scheduled for a probable cause conference.
Thank you. Before you put appearances on, as I just stated, it's a really good idea for you to mute your microphone. Rebecca's iPhone, not sure what's going on there. I'm going to start to create a waiting room. Also, if you have a device that does not indicate who you are, please rename your device so that you are identified. For instance, the device titled iPhone. It is important that you name your device to reflect your identity so we know who's here. And Rebecca, you're going to go into the waiting room, okay? Appearances, please.
Good morning, Your Honor. Rana Hadid on behalf of the people, P62243.
Good morning, Your Honor, to your staff, everybody attendance, DeRaid Elder, on behalf of Mr. Joka. My P number is 57728.
And good morning, Your Honor. Jamil Kuja appearing on behalf of Christine Putros. My P number is 71963.
Okay, is Mr. Joka here?
Yes,
Could you please state your name?
John Joker.
Thank you. Okay.
You are
What is your pleasure, defense counsel?
Yeah, I'm asking the court to have this matter set for a PCC. I've received no discovery whatsoever. A little bit, I know there's body cams and
I'm sorry, Mr. Elder, your audio is going in and out. We're only hearing like every third word.
Yeah, I'm asking the court to set this up for a PCC. I have just been recently retained. I don't have any discovery, and I have, I believe there's some audio and body cameras. So I'm asking the court to adjourn this matter for another PCC. If not, Judge, just give me a little extra time. I know the exam has been set previously for July 15th. So if the court can give me a little extra time to make sure I have discovery.
Okay. Is your client in custody?
He is, Judge.
Okay, so you do not want the July 15th exam date?
Judge, if we can get a couple days extra just to ensure that I have full discovery. I know it's scheduled for the 15th, but if the court can squeeze us in on the 19th, that'd be great.
Well, here's our challenge, though. We gave the July 15th date at 1:30 because of the fact that this is a double bagger and we were trying to accommodate. But we, well, as you know, Mr. Elder, I don't think I need to tell you, we're spilling over. We don't have options to pull out the bag here. So if you want another date, then that will be at the defense request, and that's probably not going to be until August. We've got homicides every afternoon.
Well, Judge, if that's the case, let's leave it for the 15th, Your Honor. I'd like to talk to my client about this, see where discovery goes. And then what I'll do is I will contact the court with Ms. Hadid's permission if something changes.
Okay, counsel for futures?
Judge, I'm in the same boat. I was just retained. I don't have discovery, but hopefully we can get it in time to be prepared to hold the exam on July 15th. And if
Did your
there's an
client put her name on the record first? Let me start there.
okay.
Can you put your name on the record?
Ms. Putros, just state your name.
You have to unmute.
Good morning, Your Honor. Christine Putros.
Good morning. Okay, so let me tell you what my first concern is, though, Ms. Hadid. Is this your case?
Yes, Judge.
This was from June 15th, PCC.
Yes.
So I'm just curious as to why neither counsel have discovery?
Because they were retained last night. I gave it to the
Okay.
previous appointed counsel.
Okay, all right. So again, July 15th is the date. Unless I hear otherwise, we're going to hold to that date.
Sounds good, Judge. You said that's at
Okay.
1:30?
At 1:30, one of the defendants, Mr. Joka, is in custody, and the court did its best to accommodate setting an exam date that's as close as possible because of his in custody status. So if there is a need, I certainly don't want you to proceed without having reviewed the discovery. But seeing as though it has been sent, I'm hoping this is going to afford an opportunity for that discovery to be thoroughly reviewed and discussed with your respective clients. If there is a need to adjourn from that date, let us know as soon as possible, because there's surely another exam that can fit in that time slot. So July 15th at 1:30 is going to be the exam date. Is there anything further?
Judge, in terms of co-defendant, I'm not sure if they were charged together or they were charged independently, Your Honor. But I have very little information here, but I'm just questioning whether or not this should be a two-bagger or not.
They are,
After review discovery, Judge, I guess we can deal with that later date.
Did you wish to address that, Ms. Hadid?
yes, Judge. They are co-defendants, same conduct, transaction, date of offense. They were just charged on different dates.
Okay, does that answer your question?
It
I
does,
guess,
Judge.
Judge, we'll look at the discovery, and if we think there's an issue to bifurcate them, we'll raise it. But at this point, we don't have the information that Ms. Hadid has, so we'll just wait.
I'll
Okay.
email everything over today, Judge.
All right, perfect. So again, July 15th at 1:30. And we will see everyone then.
Thank you.
Thank you, Your Honor.
I'm gonna see you.
Thank you.
Thank you.
Thank you.
Wayne County Division 2, what's your name, sir?
Hey, good morning, Tammy. We have two over here at Division 2. This is Mr. Hubbard, Eugene Hubbard,
Okay,
and we also
Okay.
have a Darius Lanier.
okay, all right, thank you. All right, they're both on the same, but they can't bring them both to video at the same time, so I'll do Mr. Hubbard first. Calling parties,
Tammy, I don't think Mr. Makepeace is here yet.
Is he not? Okay. Just let me know. Do you have a text or something? You can shoot him a text and let him know that we're ready to call this.
Yeah, he said he's be out in roughly 20 minutes, about 5 minutes ago.
Okay,
I'll let him know.
okay, thank you. Do I have the special prosecutor on Appling and Bannister?
Yes, Your Honor, I'm here. Or
This is Annie.
Madam Clerk.
Hold
Yeah.
on.
It's
calling
Prosecutor Bill
party.
Lawrence.
Okay, calling parties on Appling and Bannister, case number 2158504. The people of the state of Michigan versus defendant number 1, Keith Damon Appling. The defendant is charged with count 1, homicide, murder, first degree, premeditated. Count 2, weapons, firearms, possession by felon. Count 3, weapons, felony, firearm. Count 4, weapons, felony, firearm. Habitual offender. Fourth offense notice, defendant number 2, Natalie Brooks Bannister, is charged with count 5, accessory after the fact to a felony, count 6, lying to a peace officer, violent crime investigation. This matter is scheduled for a probable cause conference.
Appearances, please.
Good morning, Judge. William Lawrence, P70481 for the people.
Good morning, Your Honor. Austin Zima on behalf of Mr. Appling, P84670.
And good morning, Your Honor. Sarah Coaster on behalf of Natalie Bannister, P74187, and Ms. Bannister is appearing via Zoom this morning.
Okay, Mr. Appling?
Your Honor, Mr. Appling is currently being housed in Jackson County. I did speak with Special Prosecutor Lawrence this morning, and we have agreed to waive his presence for purposes of this proceeding.
Okay, so are you requesting to waive his presence?
Well, yes, Your Honor, we'd be requesting to waive his presence this morning for this PCC. Pardon me.
Okay, so yeah, because it's not something that the prosecutor grants. Certainly my concern is that when there's an individual that's charged, particularly of something of this stature, that they're privy to what's going on. So have you had, could you lay on the record some level of foundation as to, so that the court would feel comfortable waiving his presence? Have you been in communication? This gentleman?
Pardon me, Your Honor?
Have you spoken to, been into communication with this man, Mr. Appling, such that you feel comfortable waiving his presence at this proceeding?
Yes, Your Honor, we have. Our office has had a few Zoom conferences with Mr. Appling. We've spoken to him by cell phone. We will be going to visit him if all things work out tomorrow in person in Jackson County. It's our understanding that they recently lifted their COVID restrictions. So tomorrow we are able to go in and meet with him in person. But as to Your Honor's concerns as to our communication with Mr. Appling, we have been in contact with him and doing our best to communicate with him given the current situation and things that are happening regarding COVID-19.
Okay, I am curious because I noticed on June 22nd, his presence was waived as well.
Okay.
So was there not a Zoom writ?
2005.
No, there's not a Zoom writ. He's currently scheduled for a preliminary examination in Jackson. My understanding is on the 7th, or not on the 7th. Yeah, I guess it would be on July
4th.
What is that again, Mr. Zima?
July 14th.
July 14th, okay. We are going to be, based on my conversations with Mr. Zima, requesting an examination for mid-August anyways, if not late August, for a couple of reasons.
Wait, I'm sorry. Wait, let me just back up because I'm still on Mr. Appling's presence or lack thereof. So my concern is why was he not Zoom writted to be present? Is the Zoom camera operation not functioning where he is?
Judge, I can check on that.
Was a Zoom writ done?
No, I did not do a Zoom writ.
Oh. Were you expecting the court to, because the court does not do the Zoom writ, it's the prosecution.
Yeah, that is my understanding, Judge, now, and I know that that's been the procedure for a bit. If the court likes, I can do that. I know that appears to be the court's preference, and maybe we can join back up shortly.
Well, let me explain why. Let me explain my concerns on this. The defendant is charged with homicide.
I understand that, Judge.
So, I mean, sure, for efficiency's sake, we can just move this on along and just, set dates, but it's kind of important for the defendant to be not only privy by way of communications from counsel, but as much a part of the proceedings as possible. And thank goodness for technology, we are able to see one another, you and I, via Zoom. And the idea is that the defendant also would be on Zoom from Wayne County Jail, from NDOC, wherever that individual might be able to be. Now, if you haven't effectuated a Zoom writ, unless you have some special connections, I don't think you're going to be able to procure his presence here this morning.
I don't know if that could be done, this quickly, Judge. I can attempt it, but the court's probably right.
Yeah, it takes at least a week in order for them to process it. So, I mean, I guess what I'm trying to relay is that I'm concerned because oftentimes we'll have an individual whose presence has been waived repeatedly, as in this case, and they come back before the court, counsel for Appling, and say, I don't know what is going on. I have no clue. Even though I'm sure there's plenty of discussion that's happening. So it concerns me that on a matter as serious as this, can't get any more serious, that he's not privy, and he could be. He could be present by way of Zoom. So if counsel for Appling, if your representation, which is the second time this has happened, if your representation is that you wish to waive his presence, you feel he has no questions, you feel he would rather you go right ahead in his absence and him not be privy to this, and that you will be in communication with him today, tomorrow, sometime in the immediate future to relay what's going on, then I want all of that on the record. And then obviously Mr. Prosecutor has no problem with it, and then I'll acquiesce to his lack of presence here.
Yes,
Counsel
Your
for
Honor.
Appling.
Yes, Your Honor, thank you. Building off what was said earlier, we do feel comfortable requesting a waiver of Mr. Appling's appearance. Again, we have been in repeated discussions with Mr. Appling. He has also contacted our office diligently as well with questions. So there is a back and forth line of communication. Again, as to Your Honor's concerns about whether we would be in contact with him today, that is also an affirmative yes. And again, we are intending to visit Mr. Appling in person tomorrow, which would be in person, again, attorney-client meeting, given the recent lift of the COVID restrictions.
Okay, I will waive his presence, given those representations that have been on the record, placed on the record here. So this is a matter of setting an examination date. And if I heard you correctly, I didn't mean to interrupt Mr. Lawrence, but I just wanted to get the record very clear as it relates to Mr. Appling's presence. You were saying, Mr. Lawrence, that you're requesting a mid-August exam date?
Judge, in speaking with Mr. Zima, the counsel for Mr. Appling, that is the request. Again, there's another case in Jackson with a examination date currently set for July 14th. I don't know if, based on what I've been told, that's going to go or not. But in any event, the request is for a date in August. And I don't believe that there's any issue with Miss Bannister, who's out on bond. And I think Miss Coates can speak to, Miss Coaster can speak to, I think they're fine with whatever date is set for Mr. Appling.
That is accurate, Your Honor. We have been speaking with Attorney Lawrence. I emailed him this morning and let him know, obviously, that we're aware with the more serious charges. Mr. Appling's case will kind of guide how this matter proceeds. At this point in time, we would be requesting a preliminary examination, and we would leave the date to this honorable court.
Thank you. How many proposed witnesses for the prosecution?
Judge, the safe number right now would be 6.
So it probably is going to make the most sense to set 2 dates, because the likelihood of us getting through 6 witnesses with 1 direct and 2 cross examinations potentially is not very high. So we're going to have to try and configure 2 dates as back-to-back as we possibly can. And you're suggesting mid-August, so I'm going to ask Madam Clerk to look at the week of August 16th.
August 16th and 17th at 1:30.
16th and 17th at 1:30.
That works for the people.
Your Honor, that works for us as well.
Counsel for Appling?
Us as well, Your Honor. Thank you.
Okay, the exam date will be in person. So Mr. Lawrence, the court, again, we do not process the Zoom not Zoom, but the in-person writ, the transportation writ, that does need to be done by the prosecution. So I don't want us to land here on August 16th and for everyone to ask if we have writted out the defendant. That is something that the prosecution would present for this court's signature. He would be writted out. Once that is processed, they do need probably more time than they did pre-pandemic in order to effectuate and process that. So please make sure that those Ts are crossed and Is are dotted.
Yeah, understood, Judge. And if I anticipate everything is going to be fine as far as writing him over for that date, if there's any issue, I will bring it up with the court and counsel, of course. But I have no reason to believe it's going to be an issue.
Okay, perfect. So you'll be presenting the court with that proposed writ.
Correct, Judge.
All right, thank you very much. If you could forward it to Madam Clerk, her email should be the very top of the chat. Or you can always call her and she'll give it to you.
Yep.
Anything further?
Nothing from the people.
Nothing from Ms. Bannister, Your Honor.
Nothing for Mr. Appling, Your Honor. Thank you.
Any concerns regarding bond?
No, Your Honor, not at this time.
None for our client, Judge.
Ms.
No, Your Honor.
Prosecutor? Thank you. Bond will continue for Ms. Bannister. All right, thank you.
Thank you, Judge.
Thank you, everyone.
Calling parties on Stanton. Case number 2157590, the people of the state of Michigan versus Jarrell Mack Stanton. The defendant is charged with count 1, home invasion, first degree, count 2, domestic violence. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Jacob Bloomers, P77307 on behalf of the people.
Good morning, Mr. Bloomer.
Is Mr. Kuja in the hallway?
I don't know, wasn't he on Zoom earlier?
He was, but he has in-person
Oh, yeah.
scheduled at 9:30. So we may have to recall this one.
I don't see him out there yet.
Okay, I'll recall it, but I have another one for you though. Calling parties on Johnson. Case number 2157851, the people of the state of Michigan versus Irvon Porter Johnson. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, domestic violence. This is scheduled for probable cause conference.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
And good morning, Your Honor. For the record, Robert Cantor, P24993, appearing on behalf of Irvon Johnson. Your Honor, I do not know if my client is on Zoom today. I have a problem. I have been unable to get in contact with him. His phone number is out of service, and the letters I've written to him, although they have not been returned to me, I have not heard from him.
Irvon Johnson. Irvon Johnson. Going once. Going twice. Mr. Irvon Johnson, are you here? Okay, today is a PCC, and this is not the first time that Mr. Irvon Johnson has decided not to join us. Is that correct? We were here.
That's
on
correct,
June
Your
7th.
Honor. His presence was waived on June the 7th. And I had requested the video, which I have not received yet, but I did receive paper discovery. But I was thinking that I would have to procure the services of an investigator to find him because as I said, I've been having trouble contacting him.
When you say trouble, have you had any contact with your client?
Your Honor, I have not.
Counsel? Mr. Prosecutor?
Your Honor, the people move for Capias.
It is currently 9:24. This matter was set for 8:30, and unlike other situations wherein counsel can represent that they've been in communication with their respective client and explain that why the defendant may not be able to appear here today and request their presence be waived, which I certainly grant freely, pretty freely. This is a situation that is distinct in that counsel has not been able to establish any contact with the defendant. The defendant was out on a $7,500 personal bond. There was no GPS tether that was ordered at the time of arraignment by the magistrate. There was indeed, however, no contact provision, and that appears to be it. And with there being no sign of the defendant, have we received any phone call from the defendant?
No, no calls.
Okay. I am going to grant that motion for Capias. Capias is going to issue. Previous bond is forfeited. New bond is going to be set at $10,000 cash or surety. Have you been in contact with the complainant?
Not since the first PCC. I spoke to her briefly, but I haven't been made aware of any violations.
Bond is going to be set at $25,000 cash or surety with GPS tether. Thank you, Mr. Cantor. Oh,
Thank
Mr.
you, Your
Cantor,
Honor. Yes.
in the event you're able to, I don't know, if he rings your phone or something,
Right.
it would be great if you could just zoom on in with him if that's before the 12:30 hour.
I will, hopefully he will do that, and I will do that if he contacts me. Thank you, Your Honor.
Anytime after that, however, if it's anytime after that, the KPS will be entered, and he will need to avail himself in the ordinary course of when an individual has an open warrant.
Understood.
Okay, thank you so much.
Thank you. Have a good day.
You too.
Calling parties on Lanier and Hubbard. Case number 2159013. The people of the state of Michigan versus defendant number 1, Darius Avante Lanier. The defendant is charged with count 1, homicide, murder, first degree premeditated. Count 2, 3, and 4, assault with intent to murder. Count 5, weapons, firearms, discharge from vehicle causing death. Count 6, weapons, firearm, discharge from vehicle causing injury. Count 7 and 8, weapons, firearms, discharge from vehicle. Count 9, 10, 11, 12, 13, 14, 15, and 16, weapons, felony, firearm. Defendant number 2, Eugene Meredith Hubbard, is charged with count 1, homicide, murder, first degree premeditated. Count 2, 3, and 4, assault with intent to murder. Count 5, weapons, firearm, discharge from vehicle causing death. Count 6, weapons, firearms, discharge from vehicle causing injury. Count 7 and 8, weapons, firearms, discharge from vehicle. Count 9, 10, 11, 12, 13, 14, 15, and 16, weapons, felony, firearm. These matters are scheduled for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Matthew Makepeace on behalf of the people, P82796, with respect to both defendants.
Good morning, Judge. Patrick Nineheist, P76343, on behalf of defendant number 2, Mr. Eugene Hubbard, is present via Zoom from the Wayne County Jail, and we consent to a Zoom hearing today.
Please state your name, sir.
Eugene Hubbard.
Yeah. Counsel for Lanier.
It's Miss James. She's been on.
She's signed on. Okay, I don't know.
Ms. James, are you here? Okay, let's call another matter.
Can I see who's in Division 1?
Division 1, please state your name.
Martina Alexander Green.
Judge, I'm counsel for Miss Green. This is Stephanie Farkas. If I could have a brief breakout room with her.
Absolutely. Is that second computer? Is that the device listed as second computer?
Division 1, floor 8.
And does it say second? Okay, okay. Well, Ms. Farkas, if I put you in the wrong room, just come on back.
Will do, Judge. Thank you.
One's mobile, I think that's it. Do I see Ms. Woodside here? Do we have anyone else checking on the 9:30?
Good morning, Ms. Woodside. Good morning.
On files? Is your client in the hallway?
Yes.
Okay. I don't have anything at the moment to call, Judge.
But there she
is.
All right, recalling, well, I don't think we called another case, so we're on the record, People versus Lanier and Hubbard. Did you want to put your appearance on? The case has already been formally called, Ms. James.
Thank you, Your Honor. Nicole James, appearing on behalf of Darius Lanier.
Thank you. Okay, Mr. Nyheiss and Ms. James, do you have discovery in these matters?
No, Your Honor, not yet.
No, Judge, not yet. Thank you.
Mr. Makepeace?
Judge, I've been in contact with both Mr. Nyheiss and Ms. James about discovery. Over the weekend, I sent them protective orders regarding the digital discovery in this case. I believe that one of the protective orders have been sent to the court. As you can imagine, there is voluminous discovery in this case. I believe that we're working towards making arrangements for both defense attorneys to drop off hard drives so it can be done in an efficient and organized manner rather than evidence.com, which I think is more beneficial to everyone if we avoid that altogether. So I anticipate it being able to be done by the end of the week.
Okay, and I'm remiss in getting Mr. Lanier's name on the record.
Darius Lanier.
Thank you. Okay, with that being said, as it relates to discovery, what is your pleasure, Ms. James?
Judge, we would ask, I'm sorry, we will request an in-person preliminary examination.
Okay, so how many proposed witnesses, Mr. Makepeace?
Judge, this is going to be a lengthy exam that will probably need more than 2 days for. I would say roughly 6 to 7 witnesses.
Okay. What about the 18th and 19th? 18th,
Yeah, that's what
19th,
I'm
20th?
checking. We may have something before that, Judge. I went to mid-August because that's what the
Oh, right,
prosecutor was
okay.
asking for. So give me just a second. We have the 10th, 11th, and 12th.
10th, 11th, and 12th? At 1:30?
Of what month, Your Honor?
August?
Okay.
Sorry?
I thought we were talking July and then that's in 4 days. And I was
Yeah, 10th, 11th, and 12th of August works for Mr. Hubbard.
And that is good on behalf of Mr. Lanier.
Mr. Makepeace?
I may just have one moment, Judge.
And Judge, that's at 1:30.
Well, tentatively, we're waiting on Mr. Makepeace. Yes, the proposal's for 1:30 on those 3 days.
Judge, I have another exam August 10th, but
Case
the
number
11th.
21FB1537.
Sorry.
This is State of Michigan versus Alexa Gardner. Shalani for the people.
Ms. James, if you could maybe just mute your microphone.
I'm not sure what date he said he wasn't available.
Look, because I
I
couldn't hear him.
apologize. I have an exam across the hall in Judge Stanford Jones's courtroom on the 10th, but the 11th and 12th work for me.
We can do the 11th, 12th, and 13th.
That works for me.
That works for me as well, Judge.
And that's a good day for me as well.
All right, the examination, and thank you, Mr. Makepeace, for alerting us that we would likely need those more than one date, so that now we can be secured and have these dates back to back as opposed to bifurcated over span of time, which is not preferable at all. So August 11th, 12th, and 13th at 1:30 respectively each day.
Thank you, Judge.
Thank you very much, Judge. And Mr. Makepeace, I'll call you when I get downtown today to drop off the hard drive.
Sounds good. Thank you.
Perfect, thank you.
And
Thank you,
Tammy,
Anna.
I did send you the copy of the signed protective order that I signed today and Mr. Makepeace had signed previously.
Oh, okay, all right, thank you.
You're
Were
welcome.
there
And
any
I'll
other?
forward that discovery order. And Mr. Makepeace, I'll get you that that hard drive later today.
Thank you, Ms. James and Mr. Ninehouse. Have a good day,
Were
everyone.
there any other concerns you wish to raise at this time?
No, Your Honor, not on behalf of Mr. Lanier.
Not on behalf of Mr. Hubbard, but maybe I can request a DSU report just to be safe.
Sure.
And not for the people, Judge. Thank you.
Okay, thank you. Did you want a DSU report as well, Ms. James?
Yes, Your Honor, thank you.
Thank you. We're all set. Thank you so much.
Do I have to
with that baby.
Thank you, Tammy. Thank you, Your Honor. Have a great day.
Yeah,
You
me
too.
thank
Please
you.
mute your microphone. Please mute your microphone.
His name was Bryson.
Ms. Porter,
My apologies. My apologies.
can you mute your microphone? That'd be great.
Yes, ma'am.
Do I have the special prosecutor on Alexander Green?
No, that's me.
Is that you?
Yes.
Oh,
I
okay. Well, I'm not ready to call. They're still in breakout room. I just thought I didn't have them. So, all right, as soon as they come back, I'll call it. So is this, what's going on these 9:30?
Yeah, we're ready on.
What's gonna happen though? Are they holds or what's going on?
I believe the Turner Biles case is gonna hold.
Oh, there's two in the code. Okay.
Yeah, is the
Are both
codefendant,
attorneys here?
is the codefendant names in or?
Is what? I don't have them as in, so I
Okay,
don't know.
yeah, I don't think he's here yet.
Is-
Pooch
yeah.
is not here yet.
Oh, okay.
It's,
So what's going on this wood side?
that's Williams, the codefendant on that one. So it's all, I don't know if you want to wait a minute and see if they come together or not.
Oh, okay, I didn't
But
realize it was
it's
all.
good. Right now,
Okay, just let me know when stuff is ready. I don't know. We have a lot scheduled, so we can't play around a whole lot.
I think we're just waiting on Mr. Turner. He was making his way into the building. Last I spoke to Mr. Nasser.
Wow.
There's co-defendants, so they wanted to call them at the same time if they could. We don't have the attorney on, Mr. Turner, or I don't think Mr. Turner's here.
Hey, Tim,
Mr. Yes. You're here,
Um,
William?
yes, so he's on Zoom. I guess if the prosecutor wants to put on the record their adjournment on the one case, and then I don't know if the DB prosecutor is there to let us know if they're ready to proceed or what on the other cases.
So.
They're ready.
so
I'll get down there as soon as we can if they're ready.
All Sims Williams.
Okay.
And then so I have Sims Williams, then there's one Williams alone, that's mine, and then there's a third Williams, which I think is prosecutor.
I'm gonna call this jailer real quick. Calling parties on Alexander Green. Case number 2159054. The people of the state of Michigan versus Martina Alexander Green. The defendant is charged with count 1, 2, 3, 4, 5, 6, and 7, assault with intent to murder. Count 8, 9, 10, 11, 12, 13, and 14, assault with intent to do great bodily harm less than murder or by strangulation. Count 15, weapons, firearms, discharge in or out of building. Count 16, weapons carrying concealed. Count 17, 18, 19, 20, 21, 22, 23, assault with a dangerous weapon, felonious assault. Count 24, 25, 26, 27, 28, 29, 30, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, 43, 44, and 45, weapons, felony, firearm. This is scheduled for a probable cause conference.
Thank you. Before appearances, can I this is just my last reminder I really want to make on this matter. I need everyone to silence their microphones. That would be really helpful. Thank you so much. If this is a case that you're on, you can unmute when it is time for you to speak. Other than that, if you're here observing or otherwise, you really need to keep your microphones muted because you may be able to hear everything clearly, but on this end, it is very difficult. Can I have appearances in this matter, please?
Good morning, Your Honor. Bryn Bailey on behalf of the people. P84009.
Good morning, Your Honor. Neighborhood Defender Service by Stephanie Farkas, P74227, appearing on behalf of Miss Alexander Green, who's present via Zoom.
Miss Alexander Green, can you please state your name?
Good morning, Martina Alexander Green.
Good morning. Okay, we're here today for a PCC. What's your pleasure, counsel?
Judge, this case actually has quite an interesting procedural history. The file was originally charged with only one count of felonious assault, CCW, and one count of felony firearm. The preliminary examination for the incident was actually scheduled before Judge Jefferson on May 27th. In which the exam was waived and we were bound over. We had an arraignment on the information on the case scheduled in front of Judge Van Houten for last Monday, the 28th. However, the people had, in the supervisor's review of the prosecutor's office, once it got to circuit court, reviewed the file, realized in their opinion that it was grossly undercharged, and then dismissed the charges on their original file and then reauthorizes the charges and arrested Miss Martina Alexander Green on this new file with the same incident with these new charges. June 24th, I believe, was the date, Judge. And Judge, we are asking the court to set this for a preliminary exam. However, the date next week that we were originally given, I'm unavailable. I'm off for a few days next week. And additionally, this file was originally assigned with Cheryl Quick in my office, who's been off on maternity leave. She's returning from her maternity leave on July 26th. And so I've discussed it with my client, and I would ask the court, if possible, if we could set the preliminary exam date the week of the 26th sometime, just so Ms. Quick will be back and be able to, because she has more of background knowledge in terms of discovery and information on this case. And once the court makes their decision regarding the prelim date, I'd ask the court if I could address bond.
Thank you. How many proposed witnesses?
Your Honor, at this point, I don't actually know. I don't have the file, and nothing is on my database for me to review to give the court an estimation as to that. I'd be generous and say 3 to maybe 5 or 6. Without having laid eyes on the file, I have nothing more concrete than that.
Well, it looks like could be a minimum of 5, given the complaint that I'm looking at, but
that would be my estimation, and be anywhere between 4 and 6, Judge.
I do understand your concern regarding the fact that Ms. Quick is obviously well more familiar with the nuances of this matter if she was involved with it before, and that is a very interesting procedural history. I don't know that we have an afternoon that's going to be, and an afternoon is going to be the best case scenario, given what I think is going to take a little bit of time. It's a little hectic to jam that into a morning. I'm just not certain if we can accommodate even the week of the 26th because we are spilling over. So Madam Clerk, what would be the earliest date that we could accommodate an afternoon, and probably, I dare say, two?
The first available afternoon we have one date in July, and that's the 22nd, and I know that's before. She's asking for after that. The next available date would be August 10th for the afternoon. And it sounds like
We just booked the 11th, right?
We booked the 11th, 12th, and 13th. Okay. But the 10th remained open.
The 10th works for me, Judge.
Is the 16th open?
Yeah, that's what I'm looking.
So August 10th and the 16th?
Yes.
Both at 1:30, Judge?
Yes.
Does the 16th work for you as well, Ms. Farkas, in the event that we may need it?
Yes, Judge.
What I fear, in not setting a second date in a matter like this is that if we get there on the 10th and need another date, that new date, that additional date would be so far off that it does cause some concern. So I'd rather lock that in now, and if we don't need it, then we don't need it. So live exam, in-person exam, I should say, is going to be set for August 10th at 1:30 and August 16th at 1:30 respectively.
And Judge, may I address bond?
Yes, please proceed.
So Judge, when this case was initially charged, Ms. Alexander Green was given a $2,500 personal bond. I do understand there's been an increase in the charges. However, the facts remain the same regarding the incident which occurred in January of 2020. She was arraigned on the charges initially with the other case when she was given the $2,500 bond in February 1st of 2021. And that's when the $2,500 personal bond was set. So she had been out on bond regarding this incident for a little over 4.5 months, Judge, close to 5 months. And there was no issues in terms of any alleged contact. She was on tether. There was no tether violations. She remained in communication with myself and Ms. Quick when she was out and with me when I took the case over. She was fully participating in her defense. Additionally, Judge, we, again, like I mentioned, appeared for a preliminary examination hearing on May 27th, which was waived. At that time, the people raised no issues in terms of waiving the exam and consented to it. And so, Judge, I would ask the court to just consider dropping this to a 10% bond provision. Ms. Alexander Green was also working prior to her incarceration. And again, like I said, there was no issues in terms of any contact with the complainants or her tether.
Well, I would say that contrary to what you just stated, things have dramatically changed from when she was first arraigned on that earlier case that was dismissed and then caused us to be here on this complaint. Things have dramatically changed. So certainly it's not the same analysis that the magistrate would have reviewed or had at the time that that bond was set way back when. This is a totally different landscape that your client finds herself in. And there are a total of 45 felony counts here. And they include some rather serious felonies wherein the defendant is facing life. It is not an appropriate time for me to reconfigure the bond. If you would like for me to make a DSU referral, then perhaps there might be something in that report that might warrant some level of a change. I don't know. But I have not heard anything on this record that would cause me to make any deviation from what the magistrate set, which was $100,000 cash or surety. Would you like a DSU referral?
I would, Judge.
Ms. Alexander Green, you should understand, even though you're in custody, there is a no contact provision. And that means that certainly you can't have any direct contact with the complaining witnesses, plural. But it also includes indirect contact. None whatsoever. And that would include having anyone act on your behalf. I'm going to say that again. Having anyone act on your behalf through direct contact, indirect contact, any form of social media outreach, Facebook, Instagram, anything. That would be considered a violation. And though you may think, well, I'm here, I can't get much worse, it could. So it is important for you to understand that even though you are now in custody, that no contact provision is a serious one and has to be abided by. And no one would be doing you any favors by any deviation from that. Do you understand that, Miss Alexander Green? The record should reflect that she appeared to nod. Her audio must be muted. Miss Farkas, if you in
Yes,
conversation,
ma'am.
okay, thank you. If you could make sure she understands that so that there's no issues that arise later, we will return back for examination. And in the event, Ms. Farkas, that you give the DSU report in advance of the date that we've set for exam, you can always tee this up for a bond motion hearing if you'd like. Now, your client is raising her hand. Did you want her to talk?
Sure. Ms. Green, do you have a question for me or do you have a question for the
I
judge?
have a question for you.
Okay, hold on one second.
I got it. Did you want to go into a breakout room?
If we could, Your Honor.
Sure.
Your Honor, before that, I do have one request that I would like to make. I have noticed that there is no GPS tether on the bond as it currently is, where Ms. Alexander Green to be able to post. I would just ask that that condition be added should she be able to post the bond.
My understanding that that condition was ordered.
I did not see it when I looked on the ROA, Your Honor. If it is there, then it is there. If it is not, I would just ask that it be added.
Well, in my review of it, I do not see that that's listed on the paperwork. I am going to add that because certainly that should have been added. I would imagine perhaps that's either a clerical error. In the event that the defendant does post bond, is able to post bond, a GPS tether shall be required prior to. I'm going to put you in a breakout room. And Ms. Farkas, if there's anything further that you require when you come back, just let us know.
Yes, Judge, thank you.
And defense that they were on now the argument is really distinguishable because there was a lot of times.
Telephone number. Telephone number. I'm going to.
Good morning.
Hi.
Good morning, Your Honor. This is the attorney Jennifer Colthurst. My laptop connection seems to be malfunctioning, and so I have to use my cell phone. Hope
Good
everyone's
morning, Ms.
well.
Cole. How can we help you?
Pretty good if I could figure out how to reconnect internet. I'm calling in regarding Gilmer, Davion Gilmer.
Okay.
It's set for 10 a.m. in-person hearing. However, Mr. Gilmer needs to be evaluated for competency and criminal responsibility.
He's downstairs. They brought him over. He's present
I've
here
spoken.
in courthouse.
Yeah. Yeah, he's in custody.
He's present here at the courthouse. Did you want to come on in and we can put it all on the record, or what's your pleasure?
Is it possible for me to make the request for a forensic evaluation via phone?
Okay, so apparently it is an in-person exam. You're saying that you're wanting to halt the procedure in that regard and refer this for competency, and you've talked to your client about this?
I've spoken with my client, and after getting confirmation about mental illness history from the lady who raised him, his aunt, I have decided that that would be in his best interest.
Okay, Ms. Coulter,
Yeah?
prosecutor is here, but we haven't called the case, so we're putting way too much on the record. I'd rather us put it all on as opposed to having to repeat ourselves. If we could bring that gentleman up. We're gonna bring him up because certainly I want him to be privy to what's going on. If you want to stay on Zoom and we can do it that way as opposed to being here in person, that's fine too. If you could just give us a moment, things that we can all in the meantime. Thank you.
Calling parties on Sims and Williams. Is Mr.
I think he said he and his client are on Zoom together, so
Are they there now though?
I don't know.
Mr. Kuja? Mr. Williams, Derek Williams?
Yes.
Mr. Kuja, are you available?
Yes, Judge, sorry about that.
Let's stand. Calling case number 2061731, the people of the state of Michigan versus Kobe Sims. The defendant is charged with count 1, assault with intent to murder, count 2, assault with a dangerous weapon, felonious assault, count 3 and 4, assault with a dangerous weapon, felonious assault, count 5, 6 and 7, weapons, felony, firearm, count 8, weapons, felony, firearm. Defendant number 2, Derek Williams, is charged with count 9, accessory after the fact to a felony, count 10, weapons, felony, firearm. This matter is scheduled for a preliminary exam.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Please the court, Sharon Clark Woodside.
Good morning, Your Honor. Jamil Kuja appearing on behalf of Derek Williams.
Okay, I thought we were doing Kobe Sims. I'm confused.
Judge, may I have P numbers, please?
There's 2 co-defendants on.
Oh, okay. Well, if we could, first of all, if we backtrack, Ms. Woodside was putting her appearance on first. Mr. Kuja, if you could just give us one moment. Can you put your appearance on, please, again, Ms. Woodside, and include your P number for Madam Court Reporter?
Yes, Your Honor, may I please the court, Sharon Clark Woodside, on behalf of Ms. Colby Sims, who's present in the courtroom with me. My bar number is 41295.
Thank you. And Mr. Colby Sims, could you please state your name? Thank you. Mr. Kuja?
Yes, Judge, good morning. Sorry, I went out of turn. Jamil Kuja appearing on behalf of Derek Williams. P number is 71963.
719 what?
63.
Thank you. And your client?
Derek Williams here.
Thank you. Okay, today is an in-person exam?
I did at the beginning, but I can put my PPP message. Jacob Bloomers on behalf of the people, P77307.
Okay, today is an in-person exam?
Yes, Your Honor. At this time, the complaining witnesses, Dante Stewart, Paige Knox, and Deja Knox, are not present. Without their present participation, people are unable to go forward this time. All 3 were subpoenaed to be here for a 9:30 in-person preliminary exam. So people are unable to go forward this time.
Is there a motion, Ms. Woodside?
Move to dismiss, Your Honor.
Okay, on behalf of Kobe Sims and on behalf of your client, Mr. Kuja, Mr. Williams?
Sorry, I was on mute. I joined in that motion.
Thank you. It is currently 9:58 in the morning. This matter was set for an exam at 9:30 as it relates to both Derek Williams and Kobe Sims. And the prosecution has made some representations on the record with regards to their inability to proceed here today. With that being said, I am going to grant the motions that have been made to dismiss as it relates to Kobe Sims and Derek Williams. Keep in mind, Mr. Sims and Mr. Williams, that the matters are dismissed without prejudice. And what that means, in short, is that it is possible that the prosecutor can reissue. If you have questions regarding the parameter of that, or the how or the why of that, please make sure that you speak with your respective counsel and they will explain it to you in further detail. Mr. Kobe Sims, do you have on a GPS tether that needs to be removed? Mr. Derek Williams, do you have on a GPS tether that needs to be removed?
No, ma'am.
Thank you. Okay. Both sides will get a copy. Mr. Kuja and Ms. Woodside, a copy of the order of dismissal. Ms. Woodside, we're going to give you a copy to sign as the moving party on your matter. And Mr. Kuja, do I have permission to sign your name to the order of dismissal in your absence as you're in the Zoom gallery?
Yes, Judge.
Thank you. Mr. Williams, Derek Williams, you can log off. You're all set.
No, he's got 2 more cases.
Oh, he has another case?
2 more.
Oh, sorry. Please stay.
Which one on Biles and Turner?
Biles and Turner, I believe is gonna run. I only see Mr. Nasser, although I do know that, Mr. Nelson is, and his client are here. I just don't know where they went.
Yeah, they're outside.
Okay. However, there is one of the Derek Williams matters that we can address.
I'll call it right after I call Mr. Bloomers, okay? And then that should be finished up.
Calling parties on Williams, Derek Williams, case number 2061727. The people of the state of Michigan versus Derek Williams. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, weapons, felony, firearm. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Judge Jamil Kuja appearing on behalf of Derek Williams.
Derek Williams.
Okay, and today is the date and time set for a preliminary examination in this matter. Are we proceeding to an exam?
Your Honor, at this time, and I just for the record, this is set for 10:30. However, it is one of the same complaining witnesses who has the domestic relationship with Mr. Williams, which is Deja Knox. So she did not appear at the 9:30 exam. It is now 10:03. She has not appeared yet. So that's why I let the court know I was comfortable calling it a little bit early. She is not present. She was subpoenaed to be here for 9:30 on the other case. So without her presence participation, people are unable to move forward.
What time did you set this?
This is set for 10:30, but she was subpoenaed for the 9:30.
Okay, Mr. Kuja, your response, sir?
Judge, I would move to dismiss at this point since it sounds like it's unlikely we're going to hear from her at 10:30. But obviously I understand if we're all surprised and we hear from her at 10:30, then they, could ask to set aside a dismissal if you were to grant it.
This was supposed to be a Zoom exam? This was supposed to be a Zoom exam or an in-person?
I have it as live. I have it in person, just like the other one.
Okay.
For the record, I did not subpoena her individually for this one because this was set the same date and everything, so I only subpoenaed for the 9:30 a.m.
Okay. Oh, I see. All right. Well, with that being said, then she should have been here at 9:30, which she was not for the previous Derek Williams case. And let me just do my due diligence here. Is there a Deja Knox that perhaps is in the Zoom gallery by mistake? Deja Knox? Not hearing any response, and we received a phone call from a Dejanok.
No, no calls.
Okay, with that being said, is there a motion? I'm sorry, I think you already made the motion, but just to make sure, did you make a motion? Mr. Kuja?
Might be muted. Or not listening.
Mr. Kuja?
We can leave the room, I guess.
Yes, Your Honor.
You made the motion, correct?
Yes.
Okay, that motion's granted. The matter is dismissed without prejudice, as the prosecution is unable to proceed.
Okay, thank you, Judge.
Do I have permission to sign your name to
Yes, you
the
do.
order of dismissal as the moving party?
Yes, you do, Your Honor.
Thank you.
Thank you, Judge.
Got one more, Williams and calls. Calling parties on Williams, case number 2062471, the people of the state of Michigan versus Derek Aaron Williams. The defendant is charged with count 1, weapons carrying concealed. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good morning, Your Honor. Jamil Kuja appearing on behalf of Derek Williams. Your Honor, I received an email from the prosecutor Friday indicating that witnesses were on furlough and unavailable. I understand that's good cause for the adjournment. I leave it to her to make her motion.
Yes, Your Honor. At this time, the people would be asking for an adjournment. On, I believe it was Friday afternoon, after I sent out a reminder email, I was informed by the officer in charge in this case that he was on furlough. And the officer necessary for testimony and probable cause, Your Honor, is out of state on an ongoing family emergency. I don't have an estimation as to when he'll be back, given that it is an ongoing family emergency out of state. I have made that request.
Now that changes the good cause to, I'm not sure.
Your Honor,
if there can't be a time, if there's not a time specific, like he's off of, I thought it was a furlough situation for like a week or 2 weeks. But if your representation is that you do not know when, due to whatever, unfortunately, family emergency, then that changes the good cause.
I have asked, Your Honor. I did send an email requesting that information. I haven't heard back yet. I'd ask perhaps if we could maybe set a probable cause conference 2 weeks out to give me that time to get an answer.
Is there a motion?
Judge, I would move to dismiss, and if they want to reissue, they have that option. Just by way of background, we have a pending case in circuit court that's been waiting kind of in limbo to see if this case was going to catch up or not. And that case has been pending since last year, and just kind of waiting on this case to get to exam. So.
Okay, so given the representation at first, certainly I do find good cause when when there's a representation that the officer is on furlough or has an emergency, a family emergency even, any kind of emergency, just as the same deference I would give to a defendant if the counsel represented same. But the further information, thank you for your candor, Madam Prosecutor, is that there is an uncertainty as it relates to when that officer would be available, unfortunately dealing with some familial emergency that has come up. So I'm hoping everything will be okay with that officer and their family. However, I am going to grant the motion to dismiss. Now, keep in mind, Mr. Williams, Mr. Williams, I don't think you stated your name a second time or third time. Could you state your name?
Oh, Derek Williams.
Okay, Mr. Williams, this matter is going to be dismissed, but please keep in mind that it is dismissed without prejudice. And what that means is that it is possible for the prosecutor to reissue when they do know when the officer might be available. And this is this is just as a matter of course. When there's not a specific time frame that is given, then this is the action that the court deems is appropriate. It's not dismissed and forever dismissed. It's dismissed without prejudice. If you have questions about what that really means, sir, please make sure you talk to Mr. Kuja. because the likelihood of a reissuance is probably a little bit higher on this sort of a situation than it is on an individual that has reconciled with their estranged husband or wife, and will not likely ever press charges again. Please understand that there is a distinct likelihood of reissuance. Okay, Mr. Williams?
Okay.
And Your Honor, if I might just make make notes for the record, I would object to the motion for dismissal. I have established that there is good cause.
You have, but what you failed to do was, and just in any situation, even if an officer has been in an accident, right? And is going through physical therapy and, we've had that happen before. They don't know when that officer will be back on their feet. It's the same situation. It's not, it's no penalty.
No,
It's dismissed without prejudice because there's no time frame. And there has to be a time frame. If the prosecutor had said, listen, he or she is at a family emergency, and they will be back the week of the 26th. Good cause, matter adjourned. But without a time frame, and unless I heard wrong, you said there is no indication of when the officer will be done. And I appreciate, again, that candor. Without a time frame, I can't open-endedly grant an adjournment of an exam, even with the request being made for a PCC to see where things are going. There's an individual that's been charged, and this individual's been waiting for these matters to be dealt with through the pandemic and all of that. So again, I certainly do agree. You have presented good cause. I agree with you there. But then that latter part where there is no specific time frame, that is what causes me to dismiss without prejudice, so that when that officer is available, there can, if you deem it appropriate, be a reissuance. But I do understand that you need to make a record to protect yourself. So please go ahead.
Yes, Your Honor. Again, I would object to the motion to dismiss. The people have established good cause, and I believe that a request for a PCC within a close period of time is a reasonable request to see if the officer has made a return to the state. But I understand the court's ruling. Thank you for allowing me to make the record.
You're welcome. So with that being said, Mr. Kucha, I think this is the third time. I still want to ask it each time. Do I have permission to sign your name to the order of dismissal as the moving party, sir?
Yes, you do, Judge.
And Mr.
Okay, we're all set here.
Ms. Colthurst, are you still on Zoom?
Yes, I am.
Okay,
Hello?
we're gonna bring Mr. Gilmore out.
If I could
Thank
just
you.
have 5 minutes.
5 minutes, yeah. On this matter?
Yes.
Okay.
Can we maybe stand while we have Kuja still?
Oh, wait, Miss Bailey?
It's gonna be.
Wait, Miss Bailey, can you let her know? Wait, hold on.
She's aware of the situation.
Oh, okay.
I just talked to her.
Okay, thank you.
Thank you.
Oh my gosh, you guys are playing with me today.
Mr. Kuja, are you still there?
I don't even know what happened to that file.
Do I have it, Tammy?
No. Mr. Kuja? I thought he did it. Oh, he signed off.
So this is Derek Williams. Do I sign off or?
Yeah, you're all set, Mr. Williams.
Okay, thank you.
You're welcome. Let me see if I can get him back. Someone's talking to me. Oh. It's Jamila. I just need him to zoom into Judge Archer's looking for his client stance. Okay, thank you.
discovery order from the Mr. Makepeace's case. And then I am step across the hall, I'll be right back. All the way down and my heart will never. Good morning. Good morning.
Tammy, did you, I gave you on Alexander Green on.
Do you want me to call Stallworth? Calling parties on Stallworth, case number 2157690. The people of the state of Michigan versus Gerald Stallworth. The defendant is charged with count 1, weapons, firearms, possession by felon. Count 2, assault with a dangerous weapon, felonious assault. Count 3 and 4, weapons, felony firearm. Count 5, domestic violence. Habitual offender, second offense notice. This is scheduled for preliminary exam.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Good morning, Your Honor. Jessica Shive, P number 81798, on behalf of my client, Mr. Gerald Stallworth, who is standing to my right present in the courtroom, Your Honor.
Please state your name, sir.
Good morning, Your Honor. My name is Gerald Stallworth.
Thank you. Okay. Today being the date and time set for a preliminary examination, are we proceeding to same?
Your Honor, at this time, the complaining witness, Nicole Henry, is not present in the courthouse. She was subpoenaed to be here for a 10 a.m. preliminary exam. Without her present participation, people are unable to go forward at this time.
Is there a motion?
Your Honor, I move to dismiss if the complaining witness has failed to appear.
Thank you. It is currently 10:18. This matter was set for an examination at 10 a.m. And with the representations that have been made by Mr. Prosecutor, let me just ask, is there a Nicole Henry in the Zoom gallery? Nicole Henry. And have we received a phone call from Nicole Henry?
No, no calls.
That motion to dismiss is going to be granted. The matter is hereby dismissed without prejudice. Mr. Stallworth, do you have on a GPS tether that needs to be removed?
Yes, ma'am.
And was it put on as a result of this case?
Yes, Your Honor.
Okay, I'm going to add that language onto the order of dismissal. Madam Defense, I will need your signature on this order of dismissal as the moving party. And Mr. Stallworth, make sure you have a copy of this order that does include that language about your tether. We will notify the tether unit from our angle, but it's always good to have your own copy to present to them so there's no confusion about whether or not the tether needs to be removed. Is there anything further?
Nothing for the people, Judge.
Nothing further, Your Honor.
Thank you. We'll bring that paperwork to you in the hallway, Mr. Stallworth.
Mr. Mercier?
Yes.
Hi, this is Tammy. If you were checking in on Mr. Joka, he retained counsel.
Thank you so much for bringing it to my attention. I'll take care of that. Is there any way we could go
Okay.
on the record and you inform me that on the record so at least I can bill for this?
We don't have the prosecutor or anyone available. We already called the case, so, I mean,
Okay. All right. Appreciate that. Thank you.
she's not back yet. They'll bring a copy to you out in the hallway of this, okay? I'm just waiting on the prosecutor.
Oh, okay. Should I tell the whole council to step in, or?
I mean, we have another matter, if the person is here too, I always want to try to take care of that, but I
Okay.
need the prosecutor for a vote, so.
No problem. Thank you so much.
I see you there.
You know, Judge. Sorry, I got an email. So, MDOC writs, the deal with in-person writs has been 10 days in advance, right?
You
And
said
I
10
did-
days to do a Zoom writ?
No, to do an in-person writ.
Uh-huh.
Apparently, I just get an email back, it's 14 days, but only for 36. Everywhere else is 10. But now,
that?
the new rules are, if it's 36, you need 14 days, and if anywhere else, it's 10. So,
That's interesting. So 14 days to do a live and transport writ.
yeah, from MDOC.
What about Zoom writs?
Zoom is still flexible. It really has to do with how fast the slots fill up.
Oh,
Because
okay.
they just have finite slots, so it's one of those,
Okay.
theoretically, it could be done a day in advance, but usually the slots will be full. So it's,
Thank you, Your Honor.
So can I call Gilmer now?
Yes, ma'am.
And then this is gonna be a hold?
That is my understanding.
Okay, so let's get this so we can get started. We still have other stuff going.
Oh, wait, what about Miss Colthurst?
That's what I'm, Ms. Goldthirst, are you still available?
Good morning, I am.
I'm gonna call your case right now.
Thank you.
Calling parties on Gilmer, case number 21057793. The people of the state of Michigan versus Davion Gilmer. The defendant is charged with count 1, carjacking, count 2, assault with intent to murder, count 3, assault with intent to do great bodily harm less than murder or by strangulation, count 4, assault with a dangerous weapon, felonious assault. This matter is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Brenda Bailey on behalf of the people, P84009.
Good morning, Your Honor. Jennifer Colthurst appearing by cellular phone on Zoom. And I appear on behalf of Mr. Davion Gilmer. My P number is 876.
Thank you. Mr. Gilmer, can you please state your name?
Gilmer.
Thank you. Okay, today is the date and time set for a preliminary examination. And I note that Madam Defense is actually in the Zoom gallery, as she's stated. And the defendant is here in person. Are we proceeding to an exam? What's going on here? Why are you not here in person?
Your Honor, the people are prepared to proceed, although I believe before this.
Oh, I was actually asking her.
Yes, ma'am.
Your Honor, I'm respectfully requesting a pause to be placed on the case in order for my client to be evaluated. I did speak with him. I spoke with his aunt, Crystal, who was supposed to have been the legal guardian because of his long history of mental illnesses. According to his aunt, he does have a history of diagnoses of paranoid schizophrenia, anger, displacement, bipolar disorder, ADHD, for which he has been prescribed medications over, the past 10 plus years. He has been in psychiatric facilities such as Stonecrest 5 different times, the psychiatric ward at St. John Ascension, the Wellness Center, Kingswood, at least 2 times. When he was a bit younger, he's only 21 years old, but when he was a bit younger, he was at the Children's Center, Bosco. And that lengthy history has, given me great cause to address the issue of competency to assist in his defense. He was not on the prescribed medications at the time of this alleged incident. And I just want to make sure that there is no issue as regards to that. And for that reason, I'm respectfully requesting that Your Honor sign an order for an evaluation concerning competency to assist in defense and criminal responsibility, please.
Okay. I'm looking at the ROA, and this was information that you were not aware of on June 24th, correct?
That is correct. It was, the information was confirmed shortly after when I had an opportunity to speak with a family member.
Okay. Do you understand what's going on here, sir? Do you understand what's going on here, sir?
Kind of, sort of. This is my first time in a place like this.
Okay. So your attorney is requesting an evaluation for competency, okay? So that means there's not going to be an examination. Have you spoken to your client about this?
I haven't gone in great detail with Mr. Gilmer regarding this issue.
Okay, well, so that means there's not going to be an examination, a hearing here today. Your attorney, no, there is not. Your attorney has requested that you be referred for an evaluation. It means that someone's going to interview you, and then they're going to generate a report for everyone to view. And it's going to have certain findings on that report, depending on the outcome of that. Then we proceed from there. Now, here's the kicker. It takes generally 90 days for us to reschedule this. You understand? So we're going to put things kind of on ice for a moment. And there needs to be referral paperwork that will be forwarded to the appropriate entities. Did you want this an evaluation for competency and competency alone?
I prefer both competency and criminal responsibility.
Okay. So I'm assuming that you'll have a conversation with Mr. Gilmer so that he has a better sense of what's going on, because he seems just a little bit taken back by what's going on today, okay?
Yes, Your Honor.
All right, so 90 days. We need a 90-day review date. Were there witnesses that were present here today?
Yes, Your Honor, the people were fully prepared to proceed to today's examination.
October 6th. October 6th is going to be the competency review date at 8:30 via Zoom. Does that work for you?
Yes, Your Honor.
And, Your Honor, while I have Ms. Colthurst here, I was wondering if she would be willing to stipulate to the chain of custody for the green light videos.
I will stipulate to same.
Thank you, Ms. Colthurst.
Okay, we're all set
You're
here.
welcome. Thank you very much. I'll be meeting with you, Mr. Gilmer. Have a good day, Your Honor, and staff
You too.
and APA.
Thank you, Ms. Colthurst. You have a good day.
Thank you. Bye-bye.
Any other quick matters before we begin this exam?
I don't believe I have anything, Madam Clerk.
Can we get Mr. Nelson and his?
Sure, thanks.
Did Mr. Kuja come back or not?
No, I don't see him yet. On that Alexander Green, I don't see what they had checked off on the order for no weapons. She had all those guns. I don't know.
You know, it should have been,
Downstairs.
yeah.
I mean, it may have been in the order, it's just, it wasn't checked off.
Yeah, and it should
So
have
if you
been
want-
done that well, but do we have to?
I'll go back and read now and see.
Who was it?
It was Ms. Farr, yes, was the attorney on it.
Who was it?
Stephanie Hopkins.
Oh, okay. Well, yeah.
I'll go back and see what was in the system.
Yeah,
They
curious
just,
too.
they forgot to check it on the form and I'll go back and do it.
Yeah, thank you.
See, kind of like 45.
Yeah, that would seem pretty important.
Are we ready, Ms. Bailey?
Yes, ma'am, I'm sorry.
Calling parties on Turner and Gilmore, or I'm sorry, Turner and Biles. Case number 2057091. The people of the state of Michigan versus Kawan Turner. The defendant is charged with count 1, controlled substance, delivery, manufacture, schedules 1, 2, and 3, except marijuana, methamphetamine, ecstasy, and cocaine. Count 3, controlled substance, possession of marijuana, synthetic equivalents, habitual offender, third offense notice, commission of a felony with a motor vehicle advisory. Defendant number 2, Rashad Biles, is charged with count 2, controlled substance, delivery, manufacture, added to Schedule 4 by board rule. Count 3, controlled substance, possession of marijuana, synthetic equivalents, habitual offender, second offense notice, commission of a felony with a motor vehicle advisory. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Brenda Bailey on behalf of the people, P84009.
And good morning, Your Honor. Good morning to your staff. May it please this most honorable court. Mohammed Nasser, P74485, appearing on behalf of which Mr. Kawan Turner, who also appears standing behind me to the left. Sir, please identify yourself for this court.
Kawan Turner.
Thank you.
Good morning, Your Honor. Rick Nelson, P39317, on behalf of Rashad Biles, defendant number 2. State your name, sir.
Bob.
Thank you. Okay, are there any preliminary matters before we proceed?
I do not have any preliminary matters, Your Honor.
Your Honor, defense would ask for a sequestration order of any and all testifying witnesses. Certainly, we'd have no objection to the officer in charge.
And for those two, Your Honor.
Is there an officer in charge?
He is outside, Your Honor, and I'm not gonna ask for, an exception for him. I am anticipating potentially needing to call him as a witness.
Okay, so, before we move any further, I am going to respond to that sequestration request. Counsel, what do you hear on? Mr. Prosecutor?
Do we have any more in custody matters?
Not to 1:30, Judge.
And are you proceeding to examine that matter?
On the first case at 10:30 a.m., not the.
Okay, all right. How many witnesses for the prosecution in the instant matter?
Probably 2, Your Honor.
Okay. All right, sequestration will be granted, so I am going to indicate to anyone that is here in the Zoom gallery that if you're a witness or a potential witness in this matter, then you should stop from watching the proceedings. There are a few people here that I'm not certain who they are or what they're here for, so I'm going to make that blanket announcement. I see that there's Mac's iPhone, and there's Rebecca's iPhone, and then there's, I'm not sure why, News 10 apparently is here. If there's anyone, Mr. Mac, yes?
Yes, ma'am. My name is Jarrell Stanton. I've been waiting for my case to come up.
Okay, your attorney's name?
It's Mr.
I'm not for sure. It was he just did another case and then he just left out without saying anything to me.
He's going to Zoom back in. Perhaps, did he not know that he had?
I think he just got busy and forgot. I did call his office and they're supposed to be having him call back in.
Okay, as soon as we see Mr. Cujo, we'll break into the proceedings that we're getting ready to start, and we'll call your matter, okay?
Thank you.
You're welcome. Rebecca's iPhone? Rebecca's iPhone. Anyone recognize that name as an individual connected to this case? As you would have a better sense than I would.
Not from defense.
I don't believe he's connected to this case, Your Honor, from the prosecution side either.
Okay, Rebecca's iPhone, if you could just keep your device muted. I'm not sure if you're waiting for another case to be called, but the courtroom is already clamped down as a precaution that has been put in place as it relates to COVID. So there are no spectators that are inside of the courtroom, only individuals that are connected to this immediate case and those individuals working in this courtroom. The Zoom gallery, I've addressed everyone, I believe, that's been here. I'm not sure why News 10 is here, but they're at Rebecca's iPhone, but I have addressed to the extent that if they are a witness or a potential witness, that they should leave. Again, you as defense counsel and prosecutor would be far more aware of anyone that is a potential witness than I would. So I've called out those names. Mac is waiting on this case and Rebecca's iPhone has not responded. The third tier of sequestration is that this is live streaming on YouTube. So if there is anyone watching the live stream that is either a witness or a potential witness, you should stop from watching these proceedings as it may preclude you from testifying in the future. With that being said, any other preliminary matters?
Nothing for the people.
Nothing for defense, Judge.
Nothing, no.
Thank you. First witness.
Your Honor, at this time, the people would call Officer Morrow to the stand.
Good morning to you, sir.
Good morning.
Could you please state your full name and spell your first and last name for Madam Court Reporter here?
Jeremy Morrow, Jeremy. Last name too?
Oh, yes,
Morrow.
thank you. And could you please raise your right hand? Do you solemnly swear or affirm testimony that you're going to give us the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. You can have a seat up here in the witness chair. Please watch your step as you step up.
Yes, ma'am.
Once he's settled, you may proceed, Madam Prosecutor.
Thank you, Your Honor.
Excuse
Can you hear me?
Yes.
Can you please restate your name for the record?
Jeremy Morrow.
Are you currently employed at the Detroit Police Department?
Yes.
In what capacity?
Police officer.
How long have you been employed in that capacity?
Going on 4 years in September.
Were you employed in that capacity on May 11th, 2020?
Yes.
Did you in fact work on that date?
Yes.
Were you by yourself or with a partner?
I had a partner.
What was your partner's name?
Officer Glenn.
Were you in,
I'm sorry. Would you repeat that spell?
Police officer Glenn, Glenn.
thank you, officer. Were you in full or modified uniform?
Full uniform.
Can you briefly describe to the court what a full police officer uniform looks like?
Full officer uniform is blue pants, blue shirt with police on the shoulder.
Were you on foot or in a scout car?
I was in a scout car,
Was the scout car fully marked or something else?
fully marked.
Did your duties as a police officer take you to the area at or near Rosemont and Cambridge?
Rosemont and Cambridge, yes.
Is that location in Detroit,
Yes.
Wayne County?
Yes.
What, if anything, is at that location?
It's a residential area.
What brought you to that location?
I initiated a traffic stop.
So, were you in the area of Rosemont and Cambridge because that is your patrol route or something else?
I was just patrolling.
Were you driving or in the passenger seat?
I was driving.
What, if anything, did you observe that led you to initiate a traffic stop?
I observed once. I observed while driving west on 7 Mile, a silver Camaro do a burnout.
What is a burnout?
Like, making skid marks, turn on the street.
And what, if anything, happened after you observed the burnout?
The vehicle that observed you the burnout turned northbound Rosemont.
What, if anything, happened after or next?
We initiated a traffic stop.
And by initiating a traffic stop, do you mean that you turned on your siren and your lights?
Just the lights.
Just the lights? Why just the lights and not the siren?
Normally, we just turn on the lights.
Okay.
I'm gonna just ask that, even though you were working in tandem with a partner, if you could just confine your answers to I, the singular, even though we know you had a partner with you. But if you could be conscious of that, so we know what you did and you alone, as opposed to you and another individual, by using the word we.
Yes, ma'am.
Thank you.
What, if anything, happened after you initiated the traffic stop?
After I initiated the traffic stop, I stepped out of the vehicle and I approached the driver's side of the vehicle.
And when you made it to the driver's side of the vehicle, what, if anything, could you observe?
I observed 2 passengers in the vehicle.
2 passengers aside from the driver, or the driver and 1 passenger?
The driver and 1 passenger.
Do you see the driver of the vehicle here in court today?
Yes.
Could you please point to him and tell me something that he is wearing?
Your Honor, we stipulate that identification.
As it relates to
Mr. Turner.
the identity of Mr. Kawan Turner has been stipulated to as the,
Was Mr. Turner the driver or the passenger?
All I know is the driver. I don't remember his name. All I remember.
I think it should, and I appreciate your attempts to for the brevity and efficiency, but if you could please lay the identification on. I'm just trying to make clear who was who and who was where.
Yes, Your Honor.
Thank you, Mr. Nasser, though.
So, Officer Morrow, could you please look around the courtroom and tell me if you see the driver of the vehicle and tell me something that they are wearing?
Yes, he's right there. He has dreadlocks in his hair, and he has a blue mask on his face.
Your Honor, may the record reflect identification of the driver as Mr. Turner.
The record will reflect identification of Mr. Kawan Turner as described by the witness here as the driver of the automobile that he saw.
And what about the passenger, Officer Morrow? Do you see the passenger here in the courtroom today? Please stand up if you need to.
I don't see him.
On the date in question, were the people in the car wearing masks?
No.
Would it help refresh your recollection if you were to see the people in the courtroom without a mask?
Yes, possibly, yes.
If everyone could drop their mask for 30 seconds. Put your masks back on.
Now, officer, did that help refresh your recollection as to the passenger?
Not really. I thought the passenger was a little more lighter.
Yeah, I can't hear what he's saying.
I thought the passenger was a little bit more lighter in complexion.
Okay.
It's been a year,
So, after the traffic stop, strike that. What, if anything, happened after you approached the driver's side of the vehicle?
Well, I asked the driver, could he produce a license registration and proof of insurance for the vehicle?
And was the driver able to do so?
No.
What did you do after that?
I asked the driver to step out of the vehicle.
And what, if anything, happened next?
He advised me that he couldn't step out the vehicle due to the fact that he was a paraplegic.
What, if anything, did you do after that fact was disclosed to you?
Well, I was about to attempt to take him out the vehicle, but then I just thought about it and I asked the passenger of the vehicle to take him out the vehicle for me.
So at this, did the passenger of the vehicle comply?
Yes.
Were both the driver and the passenger able to exit the vehicle?
Yes.
What, if anything, did you do after the occupants exited the vehicle?
Yes, I conducted the inventory search of the vehicle because I was going to impound the vehicle.
And why were you impounding the vehicle?
Because the driver did not have a valid license.
And what, if anything, did you locate during this inventory search?
I located numerous bags of marijuana, white powdery substance, and a pill bottle.
Now, when you say pill bottle, do you mean like an over-the-counter pill bottle or a prescription pill bottle?
It looked to be something like something you can buy over the counter.
What, if anything, was done with these items once you located them?
Once I located them, at that point, I placed everything on top of the vehicle, the Camaro.
What, if anything, happened next?
I arrested the two occupants of the vehicle, and then I took the evidence down to the narcotics.
When you took the evidence, did you place those items onto evidence?
Yes.
Did those items receive specific identification numbers?
Yes.
Do you know those numbers?
Not by heart.
Your Honor, I'd ask to approach with the witness's reports that contains the lock seal numbers to be read into evidence.
Your Honor, for defense, at least for Mr. Turner, I would stipulate for the lock seal numbers. I stipulate for them.
Okay, could you read those into the record?
Yes, Your Honor. Tag number 1 for the suspected marijuana and the white powder is N057 42833. And the lock seal for the pill bottle and suspected pills is N05742838. Did you get that, Madam Reporter?
Yes.
What, if anything, was done with these suspected drugs once they were placed on or into evidence?
Period, right? Like, well, after I placed them on evidence,
What, if anything, did you do with them?
gave them I did a proper procedure, gave them to narcotics. And I guess they tested.
Okay. So when you turn them over to narcotics, is there a specific person that you turn them over to?
Well, whoever's working is at the narcotics at that moment, you turn it over to them, and you get a license number, you call to get a license number. Then once you make it to narcotics, you turn the drugs over to them.
And do you recall who you turned these suspected drugs over to on that date?
Yes, I don't know his name, we call him Flex, but I don't know his like last name.
Would Flex be either Officer Brian Johnson or Officer Stewart?
I can't tell you.
Okay. And once you turned over the drugs or the suspected drugs, I apologize, to narcotics, what, if anything, was your involvement with the suspected drugs?
Excuse me, once I turn them over,
Yes.
I leave. Once I do all my paperwork, I'm gone.
And when you turned them over to narcotics, did you physically hand them to someone?
Yes.
Did you receive any of the test results back?
Like days later, no. I mean, they do what they do. They do a little test there. Yes, you know what I'm saying?
Okay.
But the overall test, no, I didn't receive nothing. Once I left that building, I didn't get nothing in the mail or anything like that.
I'm sorry, I believe there was a third lock seal number. N05742840. Did you witness the preliminary analysis?
What you mean preliminary, like the initial?
Yes, that was conducted by narcotics.
Yes.
Would you recognize the form and return of this preliminary test?
Is it a form? No, I don't want to recognize the form. Like, I don't know if you mean like they tested in there, like they took a little bit out, they put some solution on it. That's all I.
Did you fill out a form prior to turning over the suspected drugs?
Oh, yes, I filled out a form, yes.
And does this form that you filled out have a place for the preliminary analysis to be filled out?
I believe so. I'm gonna have to look at the form. It's been a minute.
Your Honor, may I approach the witness to refresh his recollection as to my question?
Would looking at that form refresh your recollection?
Yes, it would.
Yes, you may.
Approaching defense counsels to show, and I'm going to show the witness. Permission to approach?
Yes.
Okay, yes.
Now, officer, is this the form that you filled out prior to turning over the suspected drugs?
Yes.
Is it a fair and accurate copy?
Yes.
So what I want you to do is look over it briefly and look up at me when you're done. Does that refresh your recollection?
Yes.
So on that form, is there a place for the preliminary analysis results to be written down?
Yes,
Are there such results written down on this form?
yes,
Your Honor, at this time, the people would request admittance of people's proposed exhibit 1.
Any objection?
Not for exam purposes, Judge.
Same, Your Honor.
It will be, I'm sorry, Mr. Nelson?
Same, Your Honor.
Okay, it will be admitted as people's exhibit number 1.
Officer, would you please refer to the people's exhibit 1 and tell me what the results of the preliminary test were and for what substances those preliminary results are for?
okay, it says marijuana, positive for marijuana, has an X on it. It says 1891.1. Then it says amphetamine, tested positive for amphetamine, 81.8.
And for which lock seal is that?
Nora 05742833.
And is what I've shown you the suspected and confirmed drugs that you removed from the vehicle containing Mr. Turner and a passenger?
Yes,
I have no further questions for this witness, Your Honor.
Well, I'd like to know, where did you find it? The
well,
various things that you described.
yes, ma'am. The marijuana was riddled off through the vehicle. We had big, like 2-3 big bags, like in the passenger, in the back seat behind the passenger side. It was bags of marijuana all through the car, like front seat, back seat, everywhere. The powdery substance, was from the center console, and the pill bottle, I got it from the passenger side. I'm not sure if it was like on this, or the right or left side, but it was on the passenger side of the vehicle. I believe it was like the door, the seat and the door.
I'm sorry, Your Honor, I do have 2 more questions. How much marijuana did the defendant possess?
It was,
Your Honor, I'm gonna object to the possession of any type of marijuana. That hasn't been established. Like, the same facts aren't evidence. And the question is how much alleged marijuana was in the vehicle.
Well, Your Honor, actually, since the admittance of People's Exhibit 1, that is a preliminary analysis, which is admissible in this court of law, that was not objected to by either defense counsel, state that there was in fact marijuana.
But
I'm not objecting to the,
I'm trying to understand, what is your objection again?
my objection is that the question points, how much did the defendant possess? I don't think that's factually
Oh,
evidence
I
at all.
see, yes.
Right?
But you're asking how much was recovered? That's
I
it.
will rephrase.
Thank you.
Officer, how much marijuana was recovered from the vehicle?
like 13 bags in total.
And is there a weight on the form and People's Exhibit 1?
If this 1891.1 is a weight, I don't know if it is.
Okay, then if you don't know, you don't know. That's fine. I have no further questions at this time.
Cross-examination.
Your Honor, if I may?
Yes, please.
Good morning, Officer Morrow.
Good morning, sir.
Officer Morrow, I'm gonna ask you some questions. If you don't understand, please let me know, and I'll try to rephrase in a way that you can understand. Is that fair?
Yes, sir.
Now, Officer Morrow, you already testified that you were working on or about May 11th of 2020, correct?
Yes.
And you already testified that you were working with a partner on that particular day, agreed?
Yes.
Okay, and what time of day was it that this incident occurred, if you recall?
Around, I believe, around noonish.
Noonish, okay, so it was bright outside, right?
For May Day,
Okay, so it was bright outside, correct?
it was light outside.
Okay, you indicated you've already testified that what brought your attention to this particular vehicle, and it was a 2013 Chevy Camaro, right?
Yes,
Okay, silver in color?
silver,
Okay, what brought your attention to this vehicle is a burnout, agreed?
yes,
Okay, the burnout is burning rubber, burning tires, right?
yeah,
Okay, that's a civil infraction, agreed?
yes,
Okay, and from your understanding, a civil infraction is a ticketable offense, agreed?
yes,
Okay, so based upon that, you got behind this vehicle, right?
yes.
Ultimately, you ran the license plate of this vehicle, agreed?
I didn't run it, but the license plate was ready.
Okay, it was. And you know by the fact that the license plate was red, that this vehicle does not belong to Kwan Taylor, Kwan Turner, correct?
Correct,
Okay, so ultimately upon stopping, you stopped behind this vehicle, right?
right,
And the vehicle complied with your request to pull over, agreed?
yes,
Okay, you made your way from your vehicle to the driver's side, agreed?
agreed,
Okay, and at that point in time, you had a conversation with the driver of the vehicle, right?
yes,
And the driver is my client, Mr. Turner, right?
yes,
Okay, and you asked this individual for license, registration, and ownership, agreed?
yes,
Okay, and that's based upon the civil infraction of a burnout, right?
yes,
Okay, and when you're having this original conversation, it's strictly based upon what you observed, which is this burnout, right?
yes,
Okay, and when Mr. Turner is unable to produce a valid driver's license, that's an arrestable offense, agreed?
agreed,
Okay, and that's why you asked him to get out of the vehicle, right?
yes.
Okay, and you authored a police report in this matter, right?
Can you repeat that question again? You said that fast.
Forget it, forgive me, I talk kind of fast sometimes. So, you wrote a police report about this particular matter, correct?
Yes,
And part and parcel of your training of a police officer is to write police reports, right?
yes,
And in a police report, you memorialize and you articulate the salient or important factors. So at some point in time, maybe a year later, like today, you're able to look at a report to refresh your memory. Is that fair?
yes,
So when your police report is silent, it says nothing about seeing anything originally. That's true, right?
say it again?
Yeah. So your testimony previously with Fine Sister Counsel was ultimately you searched this vehicle based upon an inventory check, correct?
Yes.
Or an inventory search, right?
Yes,
And an inventory search, from your understanding, is something that is done through Detroit Police Department policy, correct?
yes,
And that gives you the ability to tow a vehicle if an individual doesn't have a valid driver's license, right?
and or insurance.
And or insurance. And he wasn't able to produce the driver's license, right?
Right,
Okay, did you see the insurance or anything else?
no,
Okay, let me ask you this. Did you ask the passenger of the vehicle whether or not he had a valid driver's license?
I was investigating the driver.
Okay, did anybody ask the passenger if he had a valid driver's license?
I did it, so I don't know who, I can't speak for nobody else.
Okay, so you did not ask.
No,
Okay, but you did search the vehicle, right?
yes,
Okay, from your understanding of Detroit Police Department policy for impound and towing, would you not agree that if there is a driver that does have a valid driver's license, that this person can drive the vehicle away?
I can use my discretion on it, yes,
You can use your discretion on that. Is that your testimony here today?
yes,
Okay, but your discretion in this particular instance, certainly you as the officer that initiated the traffic stop did not talk to the passenger of the vehicle, right?
no.
Okay, you didn't talk to him at all. You didn't say anything.
Yes, I talked to him when I asked him to take the driver out.
Okay, but you did not ask him if he had a license, right?
I don't recall.
Okay, and if you did ask, it would be written in your report, right?
Yes,
Okay, and since it's not written in your report, it's fair to say that you didn't ask, right?
right,
Okay, because you wanted to search this vehicle, agreed?
I wanted to do my job.
Okay, and doing your job involves searching this vehicle, right?
Yes,
Okay, let me ask you this. This vehicle ultimately came to a stop in front of a residential area, right?
right,
It was 19303 Rosemont, which is what is written in your report. You have no reason to believe that's inaccurate, do you?
right,
So when the vehicle ultimately came to a stop, it was legally parked, right?
right,
Okay, and that's when you approached and had a discussion, right?
right,
Okay, now let me ask you this. Ultimately, it's your there was nothing within this vehicle that made you believe that it was in some type of conditions that would create an immediate hazard. It was running properly, right?
Right.
Okay, you've already stated that it was legally parked. We got to that. It wasn't. Now, let me ask you this. The reason for the arrest of my client was the lack of driver's license, right?
Originally, yes.
Yes, and he told you that he didn't have it, agree?
Yes.
Okay, so let me ask you this. Was my client in custody when you searched his vehicle?
Yes.
Okay, and it was you individually that searched it?
Individually, yes.
Okay, let me ask you this. On this particular day, were you equipped with body cams and body mics?
Yes.
Okay, was this information that was preserved and provided to the prosecutor's office or whomever it is that's provided to?
If she asked for it, I don't.
Okay.
That's above my pay grade.
Okay, but it was functional on this particular date,
Yes,
right?
I believe so, yes.
Okay, you believe so. All right, let me ask you this. Before you start any shift, you check to see if these items are functional, agree?
Agreed.
Okay.
Your Honor, I'm going to object to the line of questioning for relevance.
Objection overruled.
Thank you so much, Judge. Okay, and there's nothing in the report that indicates that these items were not working, agree?
Agreed.
Okay, so let me ask you this. You then searched the vehicle, right?
Yes.
And it's your testimony through the questioning of fine sister counsel that you found marijuana bags in the back seat behind the passenger, agreed?
It was, I remember he had 3 big bags there, yes.
Okay, you also indicated that you found a pill bottle somewhere on the side passenger door, right?
Yes.
Okay, you didn't find anything on the driver's door, right?
On the driver's door? No.
Okay. Ultimately, you didn't find anything on the driver either, did you?
On the driver? No.
Okay. He was cooperative, and when I say he, the driver was cooperative and he provided you with information relevant to the questions that you asked, right?
No, because originally he didn't even give me his real name.
Okay. He didn't even give you his real name?
Not originally.
Okay. How come, is that something that's listed in your report?
No, it isn't.
How come?
I wasn't the one who did it. I thought he was going to do settlements, they didn't.
Who's he?
I asked for assistance, I asked for a fingerprint research.
Okay, but ultimately, you've already testified that you wrote a report on this, right?
Yes.
And within the report, you wrote down everything that's important, salient, and should be relevant, right?
Yes, that I did. Yes.
Okay, and you would agree that there's nothing in this report of an incident that happened in May 11th of 2020 about an individual giving you an improper name, right?
Right.
Okay, let me ask you this. At some point in time, it's your testimony here today that you found something within the center console, right?
Yes.
Okay, now in order to find something in the center console, you had to open up the center console, right?
Right.
Now, the center console in a Camaro has 2 levels, right? There's an opening where there's a top spot and then there's something underneath as well, right?
I'm not a manufacturer for nor do I own the Camaro, so I can't say.
Okay, but you're the one that searched it, right?
Right.
Okay, so you don't recall where these alleged items were within the center console?
Yeah, I just know that the center console was lifted and it was there.
Okay, what else was there?
I don't recall.
Okay, but you did have to lift it in order to get to it, right?
Yes.
Okay, let me ask you this. This alleged incident happened sometime, you said around noon, sometime during the day, right?
It was during the day.
Okay, all right, you have no evidence or no testimony or no information as to how long Mr. Turner was operating this vehicle, do you?
No.
Okay. There's nothing in the report that indicates there are any further gestures or movements or anything like that when you actually stopped him, agreed?
Agreed.
Okay, and that's a fair and accurate statement, is that correct?
Yes.
And you would agree that your recollection of the incident would be far better when you wrote this report than it would be today, right?
Right.
Okay. All right, any further questions?
Just a couple of questions, John. Good morning, Officer Morrow.
Good morning, how you doing, sir?
With regards to the incident at Rosemont and Cambridge, correct, we're talking about?
Yes, sir.
And how far is Faust Street, F-A-U-S-T, from Rosemont?
False,
A couple blocks away?
Couple blocks, yes.
Okay. And with regards to the stop of the vehicle, do you have any knowledge in terms of how long the passenger was in this particular vehicle?
No.
Nothing further.
Any redirect?
No redirect, Your Honor.
Okay, thank you. You may exit the courtroom.
All right.
Pleasure meeting you, officer. Thank you.
You too.
Any further witnesses for the prosecution?
Yes, Your Honor. At this time, the people would call Officer Anton Glenn to the stand.
Okay.
Yes, please.
Mr. Blowers, do you have anything?
I got one we could do quickly, I believe. I'm gonna grab people. You'll,
You're in the hallway?
yes.
1 second, sir. We're gonna call it a quick matter, but please don't go far.
Your Honor,
Yes.
this is Greenwood. I'm running a little late. I'll be there in about 10, 15 minutes.
See you when you get here. Drive safe.
Okay, thank you.
Calling parties on Hill, case number 2062012, the people of the state of Michigan versus Kristen Hill. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault, count 2, domestic violence. This is scheduled for a preliminary exam.
Thank you, ma'am. Appearances, please.
Jacob Bloomers on behalf of the people.
Good morning, Your Honor. Max Manukian, P7634, appearing on behalf of Kristen Hill.
Good morning to you, sir. And could you please state your name, ma'am?
Kristen Hill.
Thank you. Today's the date and time set for preliminary examination. Are we proceeding to an exam?
Your Honor, at this time, the complaining witness, Robert Hill, is not present in the courthouse. This was set for an 11 a.m. exam. He was to be here at that time. Without his present participation, people are unable to go forward at this time.
Is there a motion?
Your Honor, we would move to dismiss the case.
It's currently 11:11 in the morning, and what time was this matter set for?
11 a.m., Your Honor.
Thank you. I am going to grant that motion, given the representations that have been made by Mr. Prosecutor. Keep in mind that this matter is dismissed without prejudice, which means it is possible that this can be reissued. If you have questions regarding that, please make sure that you ask your attorney to explain it to you in greater detail. Do you have on a GPS tether that needs to be removed, ma'am?
No.
Okay, counsel, I just need your signature on this order of dismissal as the moving party that I'm preparing right now.
No problem, Your Honor.
Okay, we're all set. Thank you so much.
Thank you very much, Your Honor.
Counsel?
We're back on the record in the matter of People versus Kawan Taylor and Rashad Biles, 200-57091. Please state your full name and spell your first and last name for Madam Court Reporter.
Anton Glenn, first name A-N-T-O-N, last name G-L-E-N.
If I could trouble you to make sure that you speak up nice and loud so that I can hear you. I could barely hear you say that. Well, no, I think we heard you. I'm just a little bit further away. And if you could make sure you keep your mask up. We do have paper masks that we can kind of hear through better if that's what's causing you to pull the mask down, but if you could keep it up so that we're in compliance with the restrictions that are still in place in this courthouse. Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony what you're going to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. If you'd make your way over here to the witness chair, that gate swings open towards you if you'd like to step.
Thank you, Your Honor. Could you please restate your name for the record?
Anton Glenn,
Are you currently employed at the Detroit Police Department?
yes.
In what capacity?
Patrol officer,
How long have you been employed as a patrol officer?
2 years, ma'am.
Were you employed as a patrol officer on May 11th, 2020?
Yes,
Did you in fact work on that date?
yes.
Were you by yourself or with a partner?
I was with partner,
What's your partner's name?
Officer Jeremy Morrow.
Jeremy, spelled Jeremy, Morrow, Morrow.
Yes,
Were you in full or modified uniform?
yes.
Which one?
Full.
Were you on foot or in a scout car?
Yes, ma'am.
Was the scout car fully marked or something else?
Fully marked.
Did your duties as a police officer take you to the area at or near Rosemont and Cambridge?
Rosemont and Cambridge, yes.
Is that area in Detroit,
Yes, ma'am.
Wayne County?
Yes.
What brought you to that location?
On that day, we were patrolling 7 Mile, West 7 Mile, headed east on West 7 Mile. And there was a vehicle that did a burnout on 7 Mile, heading west, then turned north on Rosemont.
What is a burnout?
Burnout was when a car, usually is when the driver puts the brake on the car and accelerates at the same time to make the wheels turn on the vehicle.
And what, if anything, scratch that. Where were you seated in your patrol car?
I was in the passenger side.
Front passenger?
Front passenger, yes.
And after observing this burnout, what, if anything, happened?
We attempted a traffic stop on the vehicle on Rosemont and Cambridge.
Did the vehicle comply with the traffic stop?
Yes.
What, if anything, were you doing while your scout car was attempting to make the traffic stop?
I was on the radio telling dispatch that we were going to initiate a traffic stop.
Your Honor, I'm gonna object to the identification of we.
If you could please confine your answers to singular as opposed to we, even though we do understand you were working with the partner. Thank you.
Yeah. I conducted a traffic stop on Rosemont and Cambridge for the community.
Did you run any sort of informational searches on the vehicle?
I did.
And what, if anything, did you learn from this informational search?
The license plate that was on the vehicle did not match the vehicle that was in the link that I ran from.
I'm sorry, the last part.
Okay, the vehicle that I ran, the license plate didn't match with the vehicle that you finished driving.
And did you learn who the registered owner of the vehicle was?
Yes.
Do you recall who the registered owner?
No.
What, if anything, did you do after the traffic stop was initiated?
I got out of my scout car and I went to the passenger side of the vehicle.
And when you approached and ultimately made it to the passenger side of the vehicle, what, if anything, did you observe?
In the back seat, I could observe multiple bags of marijuana, excuse me, and that was it.
And when you made it to the passenger side of the vehicle, was there someone seated in the passenger side?
Yes.
Did you have occasion to interact with that person?
Yes.
Can you, without telling me what was said, describe that interaction?
As soon as I walked to the passenger side of the vehicle, speaking to him, got him out of the car and detained him and put him in the back of my car.
Did you ask if this person had a driver's license?
Yes.
And did they?
No.
do you see in the courtroom either the driver and or the passenger from May 11th?
Yes.
So I'd like to start with the driver. Do you see the driver here in the courtroom?
Yes.
Could you please point to something that he is, or tell me something that he is wearing and point to him, please?
Black t-shirt.
And, Your Honor, may the record reflect that the witness has identified Mr. Page One Turner, defendant number 1.
The record will reflect.
And what about the passenger? Do you see the passenger here today?
Yes.
Could you please identify an item of clothing that he is wearing and point to him where he is seated?
He has on a polo shirt, it's sitting right there.
Your Honor, may the record reflect that this witness has correctly identified defendant 2, Mr. Rashad Biles.
The record will so reflect.
So after making contact with the passenger, what, if anything, did you do?
I detained the passenger at the investigation. The driver, coming to know that he was paraplegic, and I had to take the handcuffs off of Mr. Biles so he could remove Mr. Turner from the vehicle.
And was that removal, did that removal occur?
Yes.
And what, if anything, happened after Mr. Turner was removed from the vehicle?
After Mr. Turner was removed from the vehicle, he was placed in the scout car from Mr. Biles, and I tried to run their names through Link.
And when you ran their names through Lean, what, if anything, did you learn from that?
At first, Mr. Biles came back, but after talking with Mr. Turner, he did not identify himself properly.
What do you mean he denied to identify himself properly?
He did not tell us his correct name.
What, if anything, did you do after running Lean?
After running Lean, I went back to the car, and then searched the whole vehicle, make sure if there were any more, drugs or anything inside the vehicle.
And did you locate yourself anything in the vehicle during this search?
Yes.
What did you find?
I found it looked like it's not like a plastic baggie, but like a.
I'm sorry, it's what type of baggie?
No, not like a silver baggie, but it was kind of like a. I can't really explain it, but it was with cannabis in it.
So was it like a clear Ziploc plastic baggie, or did it have a color to it?
No, it was a clear.
Was it a Ziploc baggie or no?
I'm sorry, I thought I heard the word Nautica.
No.
No, okay. Do you mind if he switches masks, because
Do we have a paper mask available? If this is from an auditory perspective, it's easier to hear.
Oh, no, that's fine, that's fine.
Thank you, Madam Clerk.
Thank you, Judge.
She's got to take down every single word, and it's hard to guess.
I completely understand. Better?
Much better. Thank you so much.
No problem.
So I'm gonna go back. The plastic baggie that you found, was it clear or did it have a color to it?
The plastic bag that I found was clear.
Was it a Ziploc baggie or did it have some other method of keeping the baggie closed?
It was some other method of keeping the bag.
Do you recall if it was like a string or a twist tie?
Yeah, twist tie.
What, if anything, did you do with that item that you recovered?
We took it down to narcotics.
Did you place that baggie and what was in it onto evidence.
Yes,
Do you recall the color of what was inside the baggie?
yes,
What color was it?
white.
And describe what you, did you observe a preliminary analysis on this item?
Yes,
From where did you recover this piece of evidence?
this was in the, on the driver's side, kind of like under the seat.
Do you recall which lock seal number you provided or was assigned to that item that you recovered?
No.
I have no further questions for this witness.
Cross-examination.
Your Honor, if I may. Good morning, Officer Glenn.
Good morning.
Officer Glenn, I'm gonna ask you some questions, and if you don't understand, please let me know, and I'll try to rephrase it in a way that you can understand. Is that fair?
Yes, sir.
Officer Glenn, you already testified that you were working on or about May 11th of last year, correct?
Yes,
That at some point in time, you and your partner initiated a traffic stop on a gray Chevy Camaro, correct?
yes,
Oh, you've already testified that you know that neither the passenger or the driver were the owners of this said vehicle, correct?
yes,
Okay, let me ask you this. You said you've been an officer for 2 years now?
yes,
Congratulations on that. Now, officer, as part and parcel of your training as a police officer, you're taught to write police reports, right?
yes,
And when you're writing a police report, you memorialize or articulate the salient or important factors to any investigation, agreed?
yes,
Because at some point in time, perhaps a year later, like today, you'll have the opportunity to look at it to refresh your memory, correct?
yes,
Now, before coming in here and testifying, did you have an opportunity to refresh your memory through your report?
yes.
Did you have the opportunity to look at your partner's report?
No,
Only your own?
on mine.
Okay, you testified when Fine Sister Counsel asked you some questions that you originally stopped this vehicle based upon a burnout, right?
Yes.
Okay, what is a burnout?
Like I told the prosecutor, is when you put your feet on the accelerator
Right.
and at the very same time causing it to,
Perfect. So you leave a patch of rubber, for lack of better terms,
Yes.
right? Okay, and that's a ticketable offense, right?
Yes.
That's a civil infraction.
Yes.
Okay, and from your understanding, a civil infraction is a ticket, not an arrestable offense, agreed?
Yes, sir.
Okay, now, there's a difference between impeding traffic and burning a tire, right?
Yes.
Okay, you agree that your report indicates that this vehicle was pulled over for impeding traffic, right?
Yes.
Okay, why is that?
Can you repeat the question again?
Yeah. You would agree that there is a separate citation for burning rubber on a tire and impeding traffic, right?
Yes.
Okay, and in your report, it indicates that the vehicle, the Camaro, was pulled over for impeding traffic, right?
Yes.
Okay, why does your report indicate it's impeding traffic and not burning rubber?
Well, at that moment in time, that's what I thought, was a, impeding traffic.
And it's your testimony here today that you haven't talked about this with the other officer outside?
No.
Okay, you haven't looked at his report either?
No.
Okay. You also testified that, ultimately this vehicle was searched, right?
Yes.
And you yourself were a party to the search?
Yes.
Okay. You also testified that your primary, contact throughout this investigation wasn't with the driver, but the passenger of the vehicle, right?
Yes.
Okay, you also testified that you checked whether or not the passenger had a valid driver's license, right?
Yes.
Okay, how come that's not listed in your report?
Sorry, just didn't mention it in my report.
Okay,
No.
Forgive me, is it listed in your report?
No, it's not.
Okay, you would agree that's an important factor, right?
I would agree so.
Okay, however, your report is silent to that particular effect, right?
Yes, sir.
Okay, you're also aware of the fact that Mr. Turner and the passenger have medical marijuana cards, right?
No, they didn't. We were not advised about that on the traffic stop.
Okay, did you ask them?
I can't recall.
Okay, and certainly it's not listed in your report, right?
No.
Okay, you would agree that if an individual has a medical marijuana card, that he can transport marijuana, right?
Yes.
Okay. Your report indicates that this vehicle was ultimately searched incident to arrest, right?
Yes.
Okay, and that's a fair and accurate statement, is that agreed?
Yes.
You would agree that prior to the vehicle being searched, that both the driver and the passenger were removed from the vehicle, right?
Yes.
That both of these individuals were cuffed and put into the scout car, right?
Yes.
Okay, and it's only after these individuals were placed in the scout car that you, the officer or officers, proceeded to search this vehicle, right?
Yes.
Okay. You don't have any testimony or any evidence today to suggest how long Mr. Turner was in this vehicle, do you?
No.
Okay. You agree that this incident took place sometime during the day, perhaps maybe 12 or 1 o'clock in the afternoon on the 11th, which I believe is a Monday?
Yes, sir.
That while you were in this particular motor vehicle, in your scout car, behind the Camaro before initiating a traffic stop, you didn't see any furtive gestures, movements, anything of that nature, agreed?
No, sir.
Okay, and if it was, it would have been listed in your report, right?
Yes.
All right, further questions, Judge, thanks.
Mr. Nelson?
Yes, thank you.
I apologize, Mr. Nelson.
Good morning, Mr. Glenn.
Yeah, good morning.
With regards to the passenger, you've identified Mr. Biles in court today. You took him out of the car and put him in the squad car, correct?
Yes.
Do you have any knowledge or do you ask any questions on how long he had been in that vehicle?
No.
And when you discussed with him basic facts like his name, age, and address, did you find out where he lived?
Yes, at the running through here.
Was it on Foul Street?
I can't recall.
It's just a state, not a street address. Can I refresh your recollection with your report, sir? Judge, can I approach?
Yes.
Just briefly, to look at this. Recognize that?
Yes.
Okay, and on that form, your name is mentioned, and it also has Mr. Biles, and it gives an address, correct?
My name, I don't see my name on this document here.
Let me show you. That's my page for it. Okay. Right there, and then look down at the next line. To the right a little, just give an address for Mr. Biles.
Yes, it is. It still doesn't have my name on the document.
And what's the address listed for Mr.
Your Honor,
Biles?
I'm going to object for relevance.
Your Honor, obviously, it's relevant in terms of knowledge of how long he was in the car and where he lived. I think it all ties
And
together.
so are you presenting this report to the officer in hopes that it might refresh his recollection?
Yes, Your Honor, that's what I
So
asked.
if you could take a moment, and I know you're looking for your name, I believe, but any document can be used to refresh recollection. So if you could read over, I don't know how voluminous it is, looks like it's a number of pages. Read over it unless there's a particular page you're asking for him to review. And then
No,
put it
no,
down.
Your Honor, just
and then put it down when you're done.
Okay, thank you. And in this document it mentions South Street as an address, correct?
Yes, sir.
Nothing further.
Well, Your Honor, I'm going to object to that question. It didn't indicate whether or not it refreshed his recollection.
Well, you can redirect.
Yes, Your Honor.
I, to be honest with you, I don't, if there was a distinct point that council was trying to make, it didn't resonate with me either.
Well, I'll use that for argument.
Okay.
Thank you.
I mean, did you want to ask a follow-up question with regards to what you were asking? Perhaps we got lost in him refreshing
No,
his
Your Honor,
recollection.
I think I just established what I want to say.
Okay, all right. Did you care to redirect?
No.
Okay, thank you, officer. You may exit the courtroom. Any further witnesses for the prosecution?
Yes, Your Honor. At this time, the people would call Officer Brian Johnson.
Mr. Wilmers, do you have anything?
Yeah, Judge, we can call Star Jones.
Yeah.
Calling parties on Jones, case number 2156072. The people of the state of Michigan versus Star Destiny Jones. The defendant is charged with count 1, larceny in a building. Count 2, assault with a dangerous weapon, felonious assault. Count 3, domestic violence. This is scheduled for preliminary exam.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
And good morning, Judge. Neighborhood Defender Service by Jackie Pilkowitz on behalf of Mr. Jones, who is present in the courtroom. Ms. Jones, will you state your name for the record, please? 81653.
And state your name again, ma'am. In the back. Thank you. Today is the date and time set for preliminary examination in this matter. Are we proceeding to an exam?
Your Honor, at this time, the complaining witness, Courtney Strickland, is not present in the courthouse. They were subpoenaed to be here for an 11:30 a.m. exam. Without the present participation, people are unable to go forward at this time.
Is there a motion?
Yes, Judge, we move to dismiss without prejudice at this time.
This matter was set for 11:30. It's currently 11:36 in the morning, and with those representations having been made by the prosecutor, I am going to grant defense counsel's motion for a dismissal. The matter is hereby dismissed without prejudice, which in short means that it is possible Ms. Hill, this matter, Ms. Jones, that this matter can be reissued. If you have questions about that, please make sure you speak to your attorney and she will explain it to you in greater detail. Do you have on a GPS tether, Ms. Jones?
No.
Okay, I just need your signature, Madam Defense, on this order of dismissal as the moving party. It will be handed to you in just one moment. We're all set.
Thanks, Judge.
We have Mr. Kuja or no? Is he on the Zoom?
Kuja is not here, and I do not believe I have the waiting room enabled, so he's not there either.
Okay.
Okay, we're back on the record in the matter of People versus Kawan Turner and Rashad Biles, 200579091. Your name, sir, your full name, and if you can spell your first and last name for Madam Court Reporter. Could you please raise your right hand, sir? Do you solemnly swear or affirm testimony you're going to give us the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Now the prosecutor, once he's settled, your witness.
Thank you, Your Honor. Could you please restate your name for the record?
Brian Anthony Johnson.
And Officer Johnson, are you currently employed with the Detroit Police Department?
Detroit Police Officer currently assigned to the prisoner processing section of the narcotics division.
And how long have you been employed in that capacity?
Approximately 18 years.
And what, if any, involvement do you have with the current case?
I was the OIC of the case, ma'am.
And what does OIC stand for?
Officer in charge.
And as the officer in charge, what are some things that you are responsible for?
I received the reports from the officers, and I comprise those reports into one single report and prepare the warrant pad for review by APA.
Do you have any involvement with the testing of the suspected drugs?
No, ma'am.
As the officer in charge, do you, As the officer in charge, would you have received laboratory analysis results after the suspected narcotics were tested?
Not, well, verbally, I have the results from the officer that tested the narcotics.
Did you receive any State of Michigan Department of State Police Forensic Science Division test results in this case?
No, not yet. I haven't received them yet. Are you speaking of the final lab?
Yes.
No, I haven't received it yet. Not saying that it hasn't been done, because normally the final lab.
I'm gonna object, there's no question on the.
Objection sustained.
Would you recognize the final labs and the lock seal number provided to the various pieces of evidence were I to show them to you?
Fact, we reviewed my investigative report, yes, ma'am.
Your Honor, I don't even object to that. He indicated that it hadn't been received, so how can one refresh one memory if there's no recollection of it in the first place? So I'm gonna object.
Well, Your Honor, I'm going to refresh his recollection with his report as to the lock seal numbers, Your Honor.
Oh, okay.
And should the lock seal numbers match, I will move forward in that.
I think that the objection was that you said you were presenting him with the final lab results for which he testified have not come back. So if there could be clarity on what you are approaching him with.
Currently, his investigator's report, Your Honor, but then I will be, if his memory has been refreshed, I will then be pursuant to 76611B, be presenting him with the final laboratory reports.
Well, we'll do one at a time. Could you rephrase what you're approaching with, and that should probably clear things up.
At this time, I am approaching with the officer in charge's investigator report, which I will of course show to brother counsels.
Thank you.
Once I ensure that I have the entire thing.
And Your Honor, my objection will be that I don't see the point to that. He hasn't indicated that his recollection needs to be refreshed. His testimony is pretty clear that it hasn't been returned. So what are you requesting?
Objection sustained, but you were asking him questions. If you could clarify that before you approach.
Your Honor, I will. You stated just a minute ago that you had a conversation that informed you as to what the preliminary analysis of the suspected drugs were.
That's correct, ma'am.
Do you recall what items were recovered in this case?
I will have to refer to my investigative report.
I'm gonna object as to relevance. I think that's been gone over by both officers at length. What evidentiary value would that have, Judge?
Madam Prosecutor?
Well, Your Honor, I promise that this is not going to be cumulative. I do have a purpose to this. The amphetamine and marijuana have been testified to, Your Honor, as well as a pill bottle. And what was it contained in that pill bottle has not been testified to, Your Honor. That is the trail that I am going down.
Okay, and so has your witness indicated that he would need it would be helpful to look at something to refresh his recollection? Have we gotten there yet?
Yes, Your Honor. That looking at his investigator's report would refresh his recollection.
Refresh your recollection, sir?
Yes, ma'am.
Okay, over counsel's objection, you may approach.
So, officer, I'm going to ask you to review your report and look up at me when you've been able to do so.
Excuse me, I forgot my glasses in the hallway. Excuse me. Can I go get my glasses?
I believe that the court officer might have gone to get them. If not, then either myself.
Officer, I need my reading glasses to read as well, so you do not need to explain.
Permission to approach, Your Honor?
Yes.
Thank you. Okay, ma'am.
All right, so what, if any, suspected narcotics were recovered in this case?
You want me to do it per lock cell folder?
Yes, per lock, yes.
Lock cell folder N05742833 contains 14 bags.
Your Honor, I'm gonna object on reading from the record. Reading from the report. He wants to take a look at the report to refresh his memory, but reading from it.
I would agree.
Well, Your Honor, just for the lock.
If you're asking for a locked seal number, that's different, but if you're asking for something of substance beyond that, counsel, just so you're not caught off guard, a locked seal number can be read into the record, but if it's going to be something of substance with regards to the content and whatnot, he can look at it, he can refresh his recollection, and then testify, but, so it's overruled in part or sustained in part.
And absolutely, Judge, we stipulate to the lock seal number.
Let's keep it.
So, without looking down at your report, after reading the lock seal number that ends in, I believe you said 233, what was in that lock seal number?
I can't recall, but I have to look at the.
Is it contained within your report to refresh your recollection?
Yes, it is.
Would looking at your report refresh your recollection?
Yes, it would.
Okay, so as to lock seal number ending in 233, I want you to look at your report, refresh your recollection, and then look back up at me.
Contains loose marijuana.
And did looking at your report refresh your recollection as to what was contained within lock seal 233?
Yes, ma'am.
What is the next lock seal that contains suspected drugs? What is that number?
May I refer to my report?
You may look at your report for the lock seal number, and then I'd like you to look up at me.
N05742838.
Okay. And do you recall what was contained within that lock seal number?
I have to refer to my report.
Okay. Would that refresh your recollection by looking at it?
Yes, ma'am.
right, so I want you to do so, look up at me when you're done, and then wait for me to ask you a question, okay?
Yes, ma'am.
Okay, go ahead. What was so did that refresh your recollection?
Yes, ma'am.
What, if anything, was contained in lock seal folder number ending in 2838?
145 Xanax pills.
And is there a third lock seal number?
Yes, ma'am.
What is that number?
May I refer to my report?
Yes. To read the lock seal number out
Lock
loud.
seal folder N05742839.
And do you need to refresh your recollection to remind you as to what was contained in that lock seal number?
Yes, ma'am.
Would that refresh your recollection?
Yes, ma'am.
All right, please do so and then look up at me. Does that refresh?
Yes, ma'am.
Does that refresh your recollection?
Yes, ma'am.
What was contained within lock seal number 2839?
One bag of marijuana.
So I want to go back to lock seal folder ending in 2838. What, if any, analyses were done on those pills?
For the pills, they were to be checked through drugs.com.
And after you checked them through drugs.com, was any request made for them to be formally analyzed by the Michigan State Police?
Yes, Officer Stewart, who tested dope, he would have did that.
Yeah, I would make that speculation as to what some other officer may or may not have done. This officer can testify.
If this officer has personal knowledge, he can testify to it. You can certainly recross him on that if you like.
Thank you, Judge.
Do you know if Officer Stewart made that request to the Michigan State Police?
Yes, ma'am.
How do you know that?
That's a procedure when pills are confiscated because we can't test them. So we check them through drugs.com and then forward them to MSP lab, Michigan State Lab.
And have in your time as an officer with the narcotics unit, have you been in receipt of Michigan State labs in the past?
The final lab, yes, ma'am.
And you would be able to recognize a final lab report if shown to you?
Yes.
Your Honor, like I said, I probably have to assist your counsel, but the officer indicated that he hasn't received the final labs. So by presenting a document, he's going to, for all intents and purposes, contradict his previous statement. So I'm objecting to showing him any labs.
Your response?
Well, Your Honor, first of all, we've established a chain of custody. Secondly, per 76611B, as long as evidence has been shown that the chain of custody has been complete and all proper tests were run, then the admission of the laboratory results is admissible.
Your Honor, my response, if I may, please, my response would be that, like I said, Sister Counsel is doing a great job. I don't think there has been establishment of a chain of custody. The indicated Officer Stewart would have done that because that is protocol. That's not indicating that he saw that with specificity. That's what should have happened or under procedure should happen. That's not, I saw Officer Stewart do this. That's not what the testimony is. So there's a chain of custody issue.
And I would agree, Your Honor. So, chain of custody, it hasn't been established, it can't be established, because you already answered the question. He has no knowledge.
Your Honor, I believe that is incorrect. He did state that he knows that Officer Stewart sent the pills to the MSP lab and how he knew that.
Yeah, can I go out here on that?
Yes, you may.
Okay. Thank you. Officer, how you doing?
You good, sir?
Very quick. This is on my cross, so it's just a very quick question. Fine, Sister Counsel asked you a question about Officer Stewart and sending things to the Michigan State Police Lab, correct?
Yes.
Okay, you've already testified that this is procedure and this is policy and this is what should happen, correct?
Yes.
And you testified that you know this because that's what should be done by Officer Stewart, right?
Yes, sir.
Let me ask you this. Did you personally see Officer Stewart do this?
What?
Send this information to the Michigan State Police? Did you personally witness this?
Once the bag is sealed, we put it in the safe and it's forwarded to MSP lab.
Okay,
So,
no,
yes, Officer Stewart, I did see him put it in the locker in our safe.
you saw Officer Stewart put this in the lock seal,
Yes, sir.
and you saw him put what into the lock seal?
The locker folds.
Okay, and you witnessed that personally?
Yes, sir.
Okay, thank you, Judge.
Your Honor, permission to approach the witness with what has been marked as People's Proposed Exhibit 2.
Granted.
I have my two.
Oh,
Judge, may I have take one from my?
Sure. That's People's 2, and I have People's 1.
Just a moment to put it in my notes. Oh, thank you.
Permission to approach with what has been marked as People's Proposed 2.
Granted.
Officer, what is it that I just handed you?
This is a Michigan State laboratory report.
And does it appear to conform with other final laboratory reports that you have seen in the past?
Yes, ma'am.
And does that piece of paper contain the police's lock seal number?
Yes, ma'am.
What is the lock seal number on the piece of paper that I just handed you?
Nora or N 0574 2838.
And do you recognize that lock seal number?
Yes, ma'am.
Why do you recognize it?
That was on the investigative report.
For,
Narcotics that were confiscated.
do you recall which suspected narcotics or drugs that lock seal number corresponded with?
Well, it's actually on this report.
What piece of evidence is that report referring to?
Says one white container with.
Objection once again from reading from the report, Judge.
Madam Prosecutor?
Your Honor, I will lay foundation and retract that
Thank you.
statement. So the lock seal number that I've handed you matches a lock seal number that you testified to earlier as being sent to the MSP labs.
Yes, ma'am.
Your Honor, at this time, the people would move to enter the People's Proposed Exhibit 2 under 76611B.
Counsel? Not hearing any response, it is going to be admitted. As what? How do you have it marked?
People's 2.
People's 2.
Officer, what are the laboratory results on lock seal ending in 2838?
It was The results says, one tablet analyzed observations of the physical characteristics and markings on the tablets are consistent with the pharmaceutical preparation of alprazolam. Initial analysis indicate the possible presence of adenzolam, a non-controlled substance. Full analysis for identification was performed.
So the test results came back that the tablets were Xanax.
Yes, ma'am.
Do you know if either defendant in this case had a prescription for Xanax?
No, ma'am.
No, you don't know, or no, they did not?
No, I don't know.
Your Honor, at this time, the people would publish exhibits 1 and 2.
Okay,
Permission to approach the bench?
yes.
Yes, that one I got. I have no further questions for this witness, Your Honor.
Cross-examination.
None from the defense, Judge. No questions, Your Honor.
Thank you. You may exit the court. Thank you so much.
Thank you, ma'am.
Any further witnesses for the prosecution?
No further witnesses, Your Honor.
Mr. Nasser?
None, for Mr. Turner.
Mr. Miller?
Likewise, Your Honor, no witness.
Thank you. Is there a motion?
Yes, Your Honor. At this time, the people would motion to bind over on all counts. Your Honor, we heard testimony today from 3 officers indicating that subsequent to observing a burnout and neither defendant having a valid driver's license on them, an arrest was completed, and pursuant to this arrest, the officers conducted an inventory search, Your Honor. During this inventory search, they found several things. One, they found amphetamine, Your Honor, which is a controlled substance. Within the vehicle, Your Honor, I believe it was the center console that was located. Definitely within the space of the defendants, Your Honor. Additionally, a pill bottle was located containing 140 some odd Xanax pills, Your Honor, located in the driver's side door, or in between the driver's side door and, I'm sorry, not the driver, the passenger side door and the passenger seat, Your Honor. Indicating that due to the locations of these items that the defendants knew or should have known the location of these narcotics, Your Honor, definitely the marijuana was out in the open. However, being that that is a misdemeanor, it's not relevant to today's preliminary examination. And I believe that the people have established probable cause that the defendants did possess with the intent to deliver both amphetamine and Xanax, Your Honor. And that this matter should be bound over as a matter of course with questions of fact for the jury.
Response?
Your Honor, if I may. First and foremost, Judge, I want to applaud the efforts of the prosecutors. You've done a great job in trying to elicit testimony, but Judge, why are we here? Let's look at the testimony that happens. First, you have the defined testimony of Officer Morrow. Officer Morrow testifies with specificity that there is some type of burnout, that is a civil infraction, that there is a determination made that Mr. Turner is not the owner of this vehicle, that this vehicle is pulled over, that there is a discussion that happens, that there is a determination that is made, that Mr. Turner is not the owner of this vehicle, or nor does he have a valid driver's license. He's pulled from this vehicle. There's an inventory search that's produced. Let's talk about that inventory search, Judge. Officer Morrow testifies that the vehicle is legally parked. He testifies that there's no issue that this vehicle was properly operating, or there was some issue with the vehicle being able to properly operate. Impounding vehicles, Judge, or impounded vehicles, I should indicate, I apologize. One moment, Judge. is governed by MCL 257252D, which allows the police to impound a vehicle under certain conditions. If the vehicle is in such a condition that the continued operation of the vehicle upon the highway would constitute an immediate hazard.
I'm sorry,
Slow down.
Okay, sorry.
That the continued operation.
That the continued operation of the vehicle upon the highway would constitute an immediate hazard. That's not what happened here. If the vehicle is parked or standing on a highway, that's not what happened here. If the vehicle is parked in a posted tollway zone, that's not what happened here. If there's reasonable cause to believe that the vehicle or any part of the vehicle is stolen, that's not what happened here. If the vehicle must be seized for to preserve evidence of a crime. Now, that is the best argument for the prosecution. However, Judge, the testimony of Officer Morrow is that he is arrested for not having a driver's license. And he tells them that he doesn't have a valid driver's license. There is no investigation that's required within a vehicle to make that determination. If a person doesn't have a license, searching a vehicle for contraband doesn't prove one way or the other whether or not he has a license. It doesn't. But even if we were to say the search was valid, which clearly it's not, let's just say that it is. People v. Wolf, 440, Mich. 508, states that presence alone does not establish possession. You have a vehicle that certainly does not belong to my client who's a paraplegic, who's behind the wheel. There's zero testimony, and that's a direct question to both officers. Let's start off with Officer Morrow. You don't have any testimony to suggest how long this person was operating the vehicle? No. You have to open the center console to find this contraband. Yes. That the contraband, drugs or whatever have you, were found in the passenger side? Yes. Did you ask these individuals if they had a medical marijuana card? No. Would that be important? Yes. There's nothing here, Judge. Zero. But let's move on. What you have here, at best, is presence. At best. And we can't even establish how long that presence was. But let's move on now to Officer Glenn. Officer Glenn had an epiphany sitting on this stand, because his report certainly doesn't reflect any of that. His report indicates that not a burnout impeding traffic. Officer, is there a difference between impeding traffic and burnouts? Yes. Why does your report that was written back when the incident happened in 2020 reflect that it is an impeding traffic instead of a burnout? I don't know. He then states with specificity that it was a search within his report. It states, Judge, and I asked him, a search incident to arrest. That's exactly what he said. And that's an important distinction, Judge, because in order to do a search incident to arrest, one, the search of a person and or the area within the arrestee's immediate control. Purpose is to protect the officer's safety by, for example, removing weapons from the reach of the arrestee and to prevent destruction, concealment of evidence. Destruction and concealment of evidence. That's what search incident to arrest is. However, I know this court certainly was paying attention that the question posed to the officer is that when this search was done, these individuals were already in handcuffs and already placed into the back of the scout car. Yes. So that is not a search incident to arrest. Period. It's not. So what you have here, Judge, is an officer who now, 13 months later, all of a sudden has a remarkable story that changes 180 from what he originally wrote within his report. And when asked with specificity if writing reports is an important facet or part of his training, yes. Do you write down the important and salient factors? Yes. His story is now aligned with the other officer. And when asked did he have the opportunity to review the other officer's report, he said no. Let's talk about the last officer. Did a fine job after being prodded and poked and elicited a testimony. Ultimately, there's some discovery about Xanax. Sister counsel, like I said, the Minister of Justice here, did the right thing. Are you aware of the fact whether or not these individuals possess a prescription for Xanax? I don't know. There's nothing that is known here. These officers had to, well, this last officer had to be essentially spoon-fed his entire testimony by looking at these reports. In actuality, the final conclusion of what is written on these MSP labs is in stark contradiction to what he said is, hey, listen, we haven't even received it yet. But Judge, the argument, all of that is a red herring. All of that is limited to the fact of whether or not this prosecutor, and like I said, done a fine job, has established the elements of delivery manufacture, possession with intent to distribute. And the answer to that is no. There's no furtive gesture. There's no movement. There's no baggage. There's no something that is present. What you have is a vehicle that's not owned by these guys, and there's a quantity of narcotics that are present. And Sister Counsel is right that the marijuana that is found is irrelevant. They're not being charged with that. And on top of that, my client does have a valid.
They are being charged with it, but as a misdemeanor, it's not relevant.
Right, it's not a misdemeanor, and of course, this court has the ability, if it was a felony, to augment the charge. But as it relates to the felonies that are associated here, there is nothing, Judge. Zero. You have presence, and presence in and of itself is insufficient. There's elemental deficiencies that are lacked here, Judge. And the main issue is the knowledge, dominion, and control of anything within a vehicle that you simply find an individual seated in. There's nothing there. If there was something that was found on, something else to correlate him with the drugs, this would be a different story, Judge, but that's not the case. Based upon these elemental deficiencies that People v. Wolf that indicates that mere presence in and of itself is insufficient, I'm asking this court to dismiss.
Mr. Nelson?
Yeah, just sorry. I apologize. Your Honor, I would ask you, obviously, to join Brother Counsel's statements, but my client is in a sort of a separate situation. He is a passenger in a car. We don't know how long he has been in the car. It's been established that he lives a couple blocks from where this car was stopped. He doesn't have anything in his possession that can testify to relative to selling narcotics, possession of narcotics. The sole testimony and charge that he is charged with has to do with a pill bottle containing 145 pills that allegedly is found, according to the testimony in police reports, in the side pocket of a car that he does not own. He has no ties to. We don't know how long he's been in it. He was put in a squad car. He was searched. That's all we have. There's absolutely no evidence from a question of fact standpoint that he did any of this delivery of Xanax 145 pills. And even if there was a question of fact as to him, it's certainly not a delivery situation. There's absolutely no indication of that other than the pure amount.
Thank you. Now, before the response from the prosecution, please, let's not, I don't want us to spin our wheels on things that are really, while they were raised in the response. This is not simply a situation of mere presence. It is not. It is not. It is not. And was there testimony about anything coming out of any particular person's pocket? No. But that is not the only manner in which an individual can be charged. Constructive possession does exist. It is a theory for which cases do proceed, and this court considers constructive possession and dominion and control for sure. I don't want the prosecution to waste their time on certain arguments that have been raised that don't hold, they clearly, with all due respect, do not hold a lot of water in this probable cause hearing. But I would like for you to address some of the issues that have been presented without going ad nauseum on some of the issues which really just, with all due respect, don't hold a lot of water. For instance, what indicia have you presented beyond the testimony that's been presented with regards to PWID, possession with intent to deliver, on both counts?
Your Honor, the presence of 145 pills in a non-prescription bottle without a valid prescription indicates, one, the sheer amount, and the present and the way in which they have been stored would indicate intent to distribute, Your Honor. I believe
with regards to which count?
2.
Okay, what about count 1? That's also a PWID.
Yes, Your Honor. Again, Your Honor, the amount recovered in conjunction with being stored in baggies, I believe it might have been 1 or 2 baggies, would indicate at least a question of fact as to the intent to distribute, Your Honor. The narcotics were within areas accessible to both of the defendants. We heard testimony today that the license plate did not match the vehicle. And as such, Your Honor, the length of time that they would have been in the vehicle, I think is a question of fact for the jury to further ascertain whether or not there was intent to deliver or distribute, Your Honor. But as far as for a probable cause standard, I believe that the people have met, and as such, I've asked that you bind over.
Thank you. So, the testimony was pretty clear throughout the witnesses that were presented by the prosecutor's office, that there was observed burnouts that were happening, and described what that was several different times. And that based on that, there was a traffic stop. And after making contact with the driver, who was identified positively as Mr. Kawan Turner, and the passenger later identified as Mr. Biles, that the driver indicated he did not have a driver's license or any other information as it pertains to that vehicle. The defendant was arrested pursuant to both officers' testimony, and there was a search incident to arrest. Inventory search, it was coined two different things, and therein there were narcotics that were found about that car. The testimony was pretty clear with regards, after it was asked, the relation to where the individuals were seated as to where those narcotics, suspected narcotics at that time, were recovered from. Those narcotics were seized, placed on lock seal number, and forwarded to laboratory for testing. The argument that this was a mere presence and we don't know how long the individuals were in the car, that for this probable cause hearing here today, that is not something that would cause the matter to fall, because the officer cannot testify as to how long either Mr. Kawan Turner or Mr. Biles had been in that car, given the location of the narcotics that were found. This is a vehicle for which individuals that are present in the vehicle exercise dominion and control within their wingspan, certainly. And again, direct possession is an easier way to indicate someone has a substance on or about their person, but constructive possession is also a very real theory upon which prosecutor's office can proceed in these matters. And the testimony was pretty clear where in the vehicle those narcotics were retrieved from. So I am going to, now having heard the arguments that have been raised and the response from the prosecution, there is a question of fact. And certainly Mr. Nasser, along with Mr. Nelson, will likely present some of the similar arguments that have been raised today at a future, any future proceedings. They will not be thwarted from doing so, but it's a probable cause hearing. And the prosecutor has satisfied their burden to establish by a probable cause standard. Like it or not, that's what that level of proof is here at this stage. And prosecutor has cleared that hurdle. The matter is going to be bound over to the circuit court, wherein the burden of proof is going to rise substantially. And your attorney, Mr. Nasser and Mr. Nelson, at that point in time, I'm certain are going to hold the prosecution, whomever inherits this case, to that much higher standard that is required, which is beyond a reasonable doubt. This is not a beyond a reasonable doubt hearing. This is not your trial date. This is a probable cause hearing. And based on what has been presented, again, both Kawan Turner and Mr. Biles' matter is going to be bound over as charged on the felonies. The misdemeanor has been charged, the misdemeanor regarding the marijuana, but it's not relevant because we're only dealing with the felonies at this stage. That matter, that count rather, as it relates to both Kawan Turner and Mr. Biles, is going to travel along for the efficient administration of justice. The AOI date is going to be, what is it going to be? 3 weeks from now. What's today? The 6th. That would be the 27th. Yeah. July 27th at 9 a.m.
I handed back to Madam Clerk the exhibits that were marked. Mr. Bloomers, no. Gentleman in the back, can I trouble you to get Mr. Bloomers or that other prosecutor that was in here? Oh, hi, Mr. Bloomers. But there's another prosecutor, Francis, maybe?
I think there's 2 cases.
Thank you, sir.
Thank you, Judge.
Thank you.
Thank you, Judge. Always a pleasure, Judge.
Pleasure to see you. Mr. Bloomers, did you have any remaining matters, sir?
Yes, just a PCC on Stanton with Mr. Kuja, who I do see is logged in. I don't know if he's present or not.
Okay, thank you.
Oh, there he is.
Yeah, I'm here. Mr. Stanton is on. He's on my Mac's iPhone.
Okay. We're going to call it in just a moment.
Calling parties on Stanton. Case number 2157590, the people of the state of Michigan versus Jarrell Mack Stanton. Defendant is charged with count 1, home invasion, 1st degree, count 2, domestic violence. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
And Jamil Kuja appearing on behalf of Jarrell Stanton. He's present on Zoom. Mr. Stanton, can you get back on the camera and state your name?
Yes, Jarrell Stanton.
Thank you. Counsel, what's your pleasure?
Judge, we wanted to set the matter for preliminary exam.
Okay, you have discovery, sir?
I do.
Yeah, Judge. Just to remind the court, this was actually previously set for exam on June 10th, and the defendant was Capias. So the complaining witness was present at the last exam date. So I was just, hoping if possibly we could get, I don't know what the court has available. I just wanted to give the court that background information.
Okay. You already know that we're not going to be able to hold the exam though, I'm assuming, for the attorneys that have just walked in, as it's 12:21. The court does not have discretion, unfortunately, because of the union to go past 12:30. So if you could just maybe amongst yourselves, take a look at your calendars. I'm also assuming that your clients are not in custody. But let me just jump back to that while I jump back to that, if maybe you could talk. So yes, you said that there's a procedural history to the extent that Mr. Stanton had an exam date and missed the exam date. And now we're back here at the PCC stage. So is there a date maybe in late August or September? I mean, we'll try to do our best to give you an early date, but keep in mind, Mr. Stanton, the reason why this matter has been delayed is because you missed the exam.
I'm sorry, can I speak or should I just wait?
Okay. He says he didn't know about it and he wasn't aware of it, Judge. But I mean, that matter's kind of settled at this point.
We have an August date?
I'm trying to see something.
August 30th at 9:30.
You say August 30th?
Yes.
What time?
9:30.
Do you have anything a little bit later or?
I was just squeezing that in. The 31st at 10:30 or 11.
Yeah, August 31st at 11 will work. If that's okay.
Okay, live exam, in-person exam, August 31st at, did you say 11?
He said 11:30.
At 11:30.
So Mr. Stanton, we need you here on that date in the courthouse, okay?
August 31st at 11:30.
11:30, yes.
Will I receive anything or should I just remember this?
Write it down.
I will fill it, but you should write it down and put it in your phone.
Well, I have it now. It's just okay. So I'll do that now. And also, they say I have a court with you guys in a couple of days as well. So should I still attend that one as well on the 16th?
No, they had an exam for the 13th, but Judge, that's not gonna go, right? That's why we're setting this August 31st.
Right.
Yeah, you can ignore
don't
that
worry
July
about that.
13th date.
August 31st, 11:30, and it's in person. Yes, ma'am, and yes, sir.
All right.
All right, thank you.
Thank you, Judge.
Thank you.
Everybody.
Thank you, Judge. Good afternoon.
Can I leave?
You
It's
too.
okay. Bye.
Yeah, you're all set.
Thank you so much.
Mr. Greenwood, and Mr. Prosecutor, I apologize, but we had an exam there that took forever. Let's put it on the record and see, could you bring your officer in? Just so
I did tell him to leave, I'm sorry.
Oh,
He said
okay,
he-
all right, well, it seems like,
Do you want me to bring my client in?
yeah, that'd be great. Mr. Quinn, good morning to you, sir, or good afternoon. Mr. Quinn.
Mr. Gibson had two cases, correct?
That's correct.
All right. Calling parties on Gibson, case number 2060889. The people of the state of Michigan versus DeMarco Gibson. The defendant is charged with count 1, controlled substance, possession, cocaine, heroin, or another narcotic less than 25 grams. Count 2, controlled substance, possession, cocaine, heroin, or another narcotic less than 25 grams. Habitual offender for defense notice. The defendant is also charged in case number 2060888. People of the state of Michigan versus DeMarco Gibson. The defendant is charged with count 1, controlled substance, possession, substance added to schedules 1, 2, 3, or 4 by rule. Count 2, weapons, firearms, possession by felon. Count 3 and 4, weapons, felony, firearm, habitual offender for defense notice. These matters were scheduled for a preliminary exam.
Thank you. Appearances, please.
Matthew Cranston on behalf of the people, P4002.
And greetings, Your Honor. Edwin Greenwood on behalf of defendant P56556.
Please state your name.
To my right.
Please state your name.
DeMarco Gibson.
Thank you. Okay, so Mr. Gibson, as you can see, we're calling this case and your attorney isn't settling in too much because we're not able to hear the actual examination here today. This is unfortunate, but it's a carryover of how this pandemic has affected everything. Pre-pandemic, even pre-pandemic, we were, moving at a pretty intense clip, but now with the pandemic and all of the cases converging, newly initiated cases and older cases, and it's a battle to come on in here and try and get as many done as we can. And unfortunately, from time to time, there are matters that we simply cannot get to. The priority of the court has always got to be the in-custody matters that are coming in through that door. And seeing as though you are not in custody, it is affected in terms of whether or not we can hear your matter today.
The court should also indicate that at 1:30, which I would have thrown that out as an option, but at 1:30, we have another in custody matter that has been set for the afternoon, several matters for one person in custody. So with that being said, the court does find good cause to select a new date for this matter to be heard. What was the timing that you indicated again?
The OIC indicated to me, I'm sorry, not the OIC, my witness indicated he's going on vacation July 24th for 2 weeks. We'll be back on the 9th of August. We will work with Your Honor. He did indicate he preferred to do it in August, but we will work however the court wants to.
I don't think there's any way possible for us to squeeze you in the month of July without being in the same predicament that you were in today. So I think August is going to be the safer bet. And even August is looking really, really like a windstorm. Hurricane.
We may need it for in custody because we do have July 22nd afternoon open.
Okay, July 22nd. But I think we're gonna between now and then, we're gonna need to
squeeze something in there, yeah. So
if that's the only afternoon we have available, I think we should clear that one, leave that
yeah,
open for homicide.
that was my thinking too. So I don't know if they want an afternoon, I don't know.
How many proposed witnesses?
Just one.
Oh, okay, no.
For both matters?
For one matter, one, second matter, two.
Oh, the other maybe
Yeah.
after.
When you say one, we think one. Otherwise, the same thing might happen. Judge.
Right, exactly. So where are we? August?
We're in mid-August. I'm trying to find the first afternoon available. August 18th at 1:30.
That works for me.
At what time?
1:30.
Oh, yeah, that's fine. I have 11:30 down here.
Okay, sounds good. The matter will be adjourned to August 18th at 1:30 for in-person examination. And just so you have a better perspective, setting it for 1:30 essentially means there's no other case that will get in its way. Because it will be the only matter, these two files, Mr. Gibson, that will be set. So it's not like you're coming back on the 18th and maybe it will go, maybe it won't. That's a firm date to go because we're not scheduling any other matters, okay?
Okay.
All right. Anything further in this matter?
No, Your Honor.
Okay, thank you so much.
Thank you for your consideration.
Calling parties on Little. Case number 2060794. The people of the state of Michigan versus Cedric William Little. The defendant is charged with count 1, weapons, firearms, discharge, enter at a building. Count 2, weapons, felony, firearm. This is scheduled for preliminary exam.
Thank you. Appearances, please.
Good afternoon, Your Honor. Bryn Bailey on behalf of the people, T84009.
Good afternoon, Judge. Christopher Quinn, P69483, appearing on behalf of Mr. Little, who is also present.
Could you state your name, sir?
Cedric Little, Your Honor, how you doing?
Good, thank you. Unfortunately, Mr. Little, I have some bad news in that we are not able to proceed. Were there witnesses here?
Yes, Your Honor.
Oh, we will not be able to proceed in this matter today that was scheduled for an exam. I know you've been anxious to get your matter heard, just as the gentleman before you. But I have to consider the fact that this pandemic has really jammed up our schedule like you wouldn't believe. And we're trying to accommodate as many hearings as we can, but our priority are the in-custody matters, the individuals that are incarcerated, which really makes our docket very top-heavy. I explain all this because I think it's important for you to understand that I honor your time, your attorney's time, the prosecutor's time, and wouldn't have you sitting in the hallway on a wing and a prayer. We really thought we were going to be able to accommodate you here today, and unfortunately, we are not, as it's approaching, it's 12:32 by the court's clock, which means we are 2 minutes past, and we have to shut down the record for the afternoon because staff needs to take their lunch, and we're picking back up with another in-custody matter at 1:30. So unfortunately, we are not able to proceed. I do find good cause to adjourn. The record should reflect that Mr. Little is not in custody, is out on bond, and we need to find a date that would work for both prosecution and defense. How many proposed witnesses?
Your Honor, just one. However, before a date is set, I would like to address bond.
Okay.
Your Honor, I do have an incident report from December, which we had discussed about on the last time we were here, as well as the complaining witness who has indicated that she has still been receiving text messages that are of a threatening nature to her, Your Honor. This has been the second time that we're adjourning this preliminary examination for no one's fault, just that we cannot accommodate, Your Honor.
Okay, Tammy, I think we need to pull that cat out the bag, that rabbit out the bag, should I say?
July 22nd.
Yeah, July 22nd. We were saving that date for something that would need to go there, and this needs to go there. That would be at 1:30.
Yes, Your Honor. Still concerned with bond, though.
Yeah.
Like I said, I have the police report, and there is an ongoing investigation as to that incident, as well as the additional incidents since this case began, Your Honor, and both a personal protection order and a no contact order were put in place on the defendant. Your Honor, it has been indicated with not only several instances on this record, but as well as an incident report that I have in my hands, that the defendant has violated that numerous times, Your Honor. As such, I'd ask that the defendant's bond be revoked.
Is he on the GPS tether?
Yes.
Yes, Your Honor, but that has not ceased the contact or the driving by.
I wonder why he hasn't been picked up.
Yeah, that's kind of strange. Without a tether report, Judge, if he'd been driving by, that would be very simple to.
Is that there's
Those are the allegations from the complaining witness.
Pardon?
Those are the allegations from the complaining witness. I don't have a tether report as to such.
Okay, but I thought you said there was a police report that had been filed since then, right?
Yes, Your Honor, from December of 2020 is the one that I currently have in my possession, and I believe that there are others.
I wonder why it seems like there was a gap in the communication then, because he should have been picked up for the tether violation. He's on tether.
Correct, Judge.
If there was an incident wherein the police were called, that automatically should spark him being picked up.
I don't think he was on tether when this incident occurred, Your Honor. I believe
Because it was previously discussed.
one of the last times we were here, I asked that the tether be put on, but this was after the December date, Your Honor.
I see.
And I believe that for the safety of the community and the complaining witness, Your Honor, that Your Honor, and as indicated, he has been sending her text messages as recently as the last time we were here in May, and as well as during that time has been driving by her house repeatedly, probably not since the tether, Your Honor. When I requested that be put on May 26th. Your Honor, this complaining witness is terrified. And I believe that for both her safety and the safety of the community, that the defendant's bond should be revoked.
Okay, but now this isn't, before the defense responds, this is a really important question I have. I know what you've stated, but I need just to be crystal clear to me. Is there an allegation that Mr. Little has violated the no contact provision since May 26th of 2021?
No, Your Honor.
Oh, so what are you asking me to do? Because that's when I added the GPS tether. Because
Your Honor,
I certainly am, I'm prepared to talk to him, but were you asking for me to take action?
Yes, I'm asking that you revoke his bond.
Oh, well, a couple of things would need to happen. Number one, I would need some indicia that there's been some violation since May 26th, if you're saying the no contact has been violated. Number two, I need that young lady to come in here. Is she here?
She is here.
And place on the record information that would prompt me to take that sort of action and allow Mr. Quinn an opportunity to voir dire the young lady with regards to what's going on. I'm not suggesting that there's any untruth to it. It just needs to be on the record before a huge decision like revoking someone's bond is made. But I am a little confused that if there isn't anything new that is alleged to have occurred between May 26th and now, this is just, you're asking for the court to reconsider? Because we reviewed this on May 26th,
Yes, Your Honor, I know that we reviewed it, and given that it's being adjourned again in consideration with the multiple reports and multiple incidents that have are making their way through the police reporting system to my office. I believe that it is in the best interest for the safety of the public as well as the complaining witness that the defendant have significantly more limited ability to reach out and contact her and have others to do so as well.
But he hasn't violated the no contact since May 26th.
As far as I know, Your Honor, as far as I know, but given that we're getting a new date, I'm asking the court to reconsider.
Is the complaining witness here?
She just left, Your Honor.
Oh, okay. Let me tell you what my concern is, that again, I'm not hearing that there's been any new allegation of violation since the GPS tether was imposed. That's number one. Number two, Tammy, what does the rest of our week look like? Is it insane? Oh, Tammy, let me ask you this. If this don't,
As far as I know, I don't know, and I have, no one's checked in, I don't know.
But remember, because we need to, if you could, we need you to hang out. Mr. Quinn, can you be here at 1:40?
Yeah, I just have Zooms this afternoon.
Okay, we'll try and work through it. Okay. Court is in recess until 1:40.
Yes, Your Honor.
Sorry for waiting all over. Yeah, that's it. Let me see, I think I put
Excuse me. Hello. Hello.
That's when we had Dr. Martin's back up on, what holiday was that, the 40th?
Wake up.
Grandma talking about,
Wake up.
go get something to eat.
Low with them.
I don't think so. But, yeah, he gonna tell us that we play for the night is not on my shit. Johnny was like, yeah, I'm gonna go say something. Don't say that because it's gonna be a phone. But we had called grandma, she said when they drunk, she don't want to hear by herself, but they might say something.
Little nigga got push me, boy.
Who up there? I was just about to lose my you think I was so.
Why you say that though? You say it always happen to you. How many times the fuck is somebody in jail? That's cool, you ain't rock with them.
Bro, no, I stay with them niggas, but they used to wind up doing some whole ass shit, so I should have left their ass.
Are they in jail?
Bro,
Or do you wait till they come out?
bro. My stupid ass. Like, for real, the last person relationships I had, bro.
The last 4?
Yeah.
How many relationships you had?
Huh?
How many relationships you had?
I mean, I don't think you could really ask a person that question. Because, like, what's the relationship? Some people.
Fuck somebody, typing, all type of shit. It's court shit. Hey, Jay, you don't talk to nobody kids like that, bro?
She asked me for that.
I will look into getting that to you.
Thank you.
Will you stipulate to the chain of custody
No.
for the drugs?
No, no stipulations.
Okay, so today is the 6th. The 20th of July, is that going to give you enough time to tender whatever additional discovery is being desired here that's been mentioned? July 20th, Tuesday, July 20th.
May we do that in the afternoon, Your Honor? I haven't.
No, we don't do afternoon PCCs.
July 20th doesn't work for me.
July 19th.
That would be.
Can we do the 21st?
Sure. July 21st at 8:30 PCC via Zoom. And I didn't mean to cut anything off, but it's real helpful when prosecution and defense can have a conversation off the record, so there's a precise understanding of what's being sought. Put it in writing if you'd like. Okay, back on the record with the previous case, 210-575-01, People versus Dates. I don't have anything. I don't have a motion. I don't have a response.
I did
I don't
file
have
it.
exhibits. I have nothing.
I'm sorry about that, Your Honor. I did file it properly. I tried to email you a courtesy copy. I didn't get back an email, so I'll do, actually, I have a hard copy right here. Ms. Morales Smith, I also mailed her a hard copy via mail.
I'm sorry, you said you hadn't received the people's response either, and that was very concerning, because I know that I sent that to Tammy.
Okay.
So
I was looking for her. I
Okay.
haven't received anything from you.
Okay.
I haven't looked for anything from you yet.
Okay, I'm sorry.
I did receive your response. Ms. Morales.
Yeah, and I resent it this.
I received two
Sorry.
emails. I
Okay.
received 2 emails with
Sorry about
your
that.
response. No, that's okay. You're welcome. Just clear
Yep,
record.
Yep, and I am fine with the hard copy. I have read it, reviewed it, looked at it, et cetera.
Judge, would you like me to submit the hard copy to you?
Sure.
Thank you. Wait, does that say amended? It does, first amended.
Her response.
Okay, so thank you, Tammy. So you want to pick a new date?
I do, and I would like to make another bond motion for my client, Your Honor.
Sure.
So, Your Honor, we'll start with some of the facts that you've already seen in this.
Sorry, Judge, I'm sorry. Would you mind using the microphone, please?
I don't mind, thank you. We'll start with some of the facts you've already seen. We have testimony of the 2 people that were there during the event. The testimony of Ms. Hudgens says that Mr. Gates was not the driver. She could not identify him. She did not identify him prior to coming to court either. We have the testimony of the driver of the vehicle. Testimony of the driver of the vehicle was that he does not remember who shot him. You're still waiting on the testimony of Isis Terrell, who was not there. And if you haven't read the people's response yet, I'll reference this and you can please correct me if I'm wrong. But they state that Isis Terrell identified Mr. Gates from a 1-person photo lineup. That's not good enough identification. I would say that their case in terms of putting Mr. Gates there as the shooter is actually rather weak in a factual sense. I'd also like to speak to some of the medical issues. The last time we were here, we were told that Mr. Gates was not brought to court because he was in quarantine from going to the hospital. If you recall, he had gone to the hospital previously for his arm, and the next day he was brought to court here. According to my client, upon information and belief, he was not taken to the hospital for his shoulder as represented. I've been documenting this because I've been trying to get him help so that Wayne County can provide the type of medical assistance that's required. Mr. Gates does have close continuing relationships with his children, with his mother. He has a fiance. He also has a brother that he's very, very close to and a younger sister. They have been checking in on him
They have maintained those close bonds. His mother has health issues. She runs TNN Bistro Kitchen. Mr. Gates was helping her with deliveries. He was working at the family business. Also, Miss Isis Terrell is the mother of his youngest child. Mr. Gates and her are currently in a dispute in court. Mr. Gates would like the rights to the youngest child, and he has been working with his family on that for a long time. I believe that a tether with a GPS locator can ensure his presence in court for these matters. He's certainly aware of the seriousness of this offense. He's certainly been in pain while being in Wayne County Jail, physical pain. So I would ask the court to reduce his bond. There's no way he can make that bond. There's no way anybody in his family can make that bond to a more reasonable amount that he can reach that will assure his appearance and put a tether on him. Thank you.
Response? Yes, Your Honor. Any injuries that, that the defendant has received as a result of his own actions, and while I sympathize for him in not getting maybe proper treatment at the jail, that is beyond what I can help him with. But to the seriousness of the charges, this case is a very serious case. It is currently open. Your Honor hasn't heard all the testimony as yet. There's a current motion on the floor. Not to mention the additional charges, additional cases this court is hearing in relation to this defendant, plus the new charges of the new case that is being, that was part of the discovery questions as far as discovery goes. It was a brand new case having nothing to do with these situations that brought him into the custody of the Detroit Police Department as it is at the Wayne County Jail. We would ask that because the defendant doesn't seem to be able to file court orders of, staying out of trouble, responding to court dates and that such, we would ask the bond not to be changed.
It is highly unusual for the court to consider a bond motion in the middle of an examination with other matters still awaiting behind that. Notwithstanding the argument that's been made, I am not going to amend the bond at this time. The bond is going to remain where it is. And because I don't want us to waste valuable court time, I'd love to hear your argument, Ms. Sadi, that I have before me, which I do plan on reviewing with a fine-tooth comb, but I want to hear your full argument, and I'd like to hear the prosecutor's full response.
Absolutely. At this time?
Yeah, right. Right now, yes.
Well, I'd like my hard copy back. There is quite a bit of argument. There's several facts. I brought the hard copy to speak from.
Please step up to the mic.
I'll pull it up here.
Counsel, I'm having a very hard time hearing you. Please use the microphone.
It's not that record wordy. I'll pull it up on my computer. I gave her my copy.
I'm handing it back if you need it.
I said right there, right.
Here.
Thank you.
Excuse me, Your Honor. Mr. Quinn is back as well.
Oh,
Thank you. Judge, if I may, respectfully.
yes, ma'am.
It took me a really long time to write this.
Oh, I'm sorry, she can't hear you well, sorry.
I may forget some things that I have in this motion. So while I'm of course going to follow the court's request and state it verbally, there is a lot of facts in this motion and a lot of law that intertwines that I had to spend a long time. So I may forget some things that I actually have in here. So I just like to make it clear that my written motion and brief is the whole of my argument, not just my statements. Okay, so if you recall, the very first time we had a PCC via Zoom, I pointed out that
Wait, hold on. Let me, I want to also be clear myself. I don't mean to, I almost feel like, I get the impression you feel like I'm putting you on the spot. Today, you were prepared to, the two of you didn't think that you were coming in here just for a kickback of a response, did you?
I thought you were gonna rule to have an evidentiary hearing. I don't feel that you're putting me on the spot, but this is a different type of case of motion.
Oh,
So there
Again,
is,
since
I
I haven't
am
had a chance
afraid
to-
of forgetting. Yeah.
since I haven't had a chance, the record, I wanna make it clear, since I have not had a chance to receive or review it, I have no idea what you're about to argue.
And Your Honor, I'm sorry if I may. I didn't realize there was a request for an evidentiary hearing within that motion, so maybe I don't have the right copy. I saw a copy that had sanctions and, motion to dismiss.
First amended, like entitled First Amendment.
Yeah, I don't remember seeing anything that said.
I also, did send you the, see, you got the proof of service, there's that one.
Okay, so this is it.
Yeah, that one, so go to, and I found this, Your Honor, from the case law, when I was reading the type of motion I'm putting forward, how exactly to do this. This is the first one I've done. It's Q, in my request, it's request letter Q. The case that I'm citing that states that we should, the court can order or deny ordering an evidentiary hearing.
In the middle of an examination.
Yep. Is People v. Cantor. Furthermore, it is important that I had put this in writing. It's preserved in writing, it's not preserved otherwise.
Yeah, I'm sorry, Your Honor. While I was responding to most of the requests, I did not see the queue, but I can argue that as well.
Should we proceed or?
Yep.
So, if you recall, the first PCC, we were here via Zoom. I pointed out to the court that there were other warrants that were not, where he was not being arraigned. One of these other warrants was an auto theft warrant. I did have a conversation with prosecutor Jacob Slesky regarding trying to get discovery. I was not able to get discovery, there he is, on that, nor were the charges pressed until I put in this motion. I'm sorry, that's not quite correct. It took a while, basically. Now, I have been asking for, and the prosecution knows this, I had nothing on the arrest from this case. It's not in the investigator's report, and there's no discovery regarding how Mr. Dates was arrested. From the prosecutor's response, it states he was arrested for this auto case and then brought in. I was given discovery after I filed this motion. They claim were from Mr. Dates' arrest that I was then told was from the auto case that was sent from this prosecutor, not the auto theft prosecutor. I have been missing quite a bit of discovery. Since the very first day I appeared in court, the investigator and I had done a lot of background investigation. My client made a statement to police. I spent every single time we were in court, I have mentioned that statement and asked for that statement. At no time did anybody from Wayne County's prosecutor's office tell me that that statement was made from the arrest from the other case, and I was lacking all the discovery on that. So I was sent by Ms. Morales Smith under her name on evidence.com, Disco. It does say in the body, this is for the auto case, but it's also saying I don't deserve it, even though it's the arrest of Mr. Dates. So every single time we have been here, the government has known that I do not know how Mr. Dates was arrested, when he was arrested for this crime, that I do not have his statement, that I think it's for this case. And not one time has any prosecutor corrected me. Instead, I get sent video and evidence I'm told is for a different case. That's for this case, this late in the game. After all of this discovery that I've done, after all of the investigation, after numerous requests, we were here and Ms. Candace Major argued a bond motion. She made several misstatements in that bond motion that do not match the evidence, and this is where you would have an evidentiary hearing to get that in. This is where I changed my exhibits and amended it. She said there's a green light video. There's not a green light video. Closed captioned it. She says, and the prosecutor still avers in her response, the only person that identifies Mr. Dates as being on the scene, the only person, identified him from a one-person photo lineup. They are stating that this came as a still from the video. Upon review, it does not come as a still from the video. I have no chain of custody. I have no evidence showing it was taken from the video. Nothing. Not even the name of an officer who did this and turned them into pictures. A one-person photo lineup from a picture they took from I don't know where is not good enough. It also is represented in Ms. Morales-Smith's response that Ms. Isis Terrell puts him there, even though she was not there at the time. She's the mother of his child. She didn't put him there. It's not in any of my discovery. It's not in any of the videos. There's been no good ID made in this case, and the evidence has been obfuscated, and they've jumbled it around for me to think that the arrest for the other case was totally separate from this case, and waited until the 11th hour to show me. In terms of the investigation, also, APA Major stated Mr. Dates was fleeing and eluding when he was arrested. I didn't have anything showing me that, and now they're saying that it's from the other case. Well, why wasn't that made clear to me when I'm asking for discovery? Why wasn't that made clear to me when I'm making my formal request? It wasn't made clear to me. The Detroit body camera policy and the Detroit scout car video policy tell me that they can't just say, they can't just say, we don't have your client's statements. We don't have these things. Let me just read this into the record. I spent a long time on this. The shooting was March 12th. He was arrested April 29th. He was taken to St. John's Hospital. Now, at this point, I know that he was taken to St. John's Hospital as a result of the car case, not as a result of this case. I don't have any medical records regarding that. Mr. Dates, Ms. Major, so up until this point, Your Honor, before Ms. Morales-Smith, after filing this motion, sent me video that was not for her case, but was for the auto theft case. Up until that point, I had no reports and no evidence of my client's arrest, zero. I could not challenge the legitimacy of the arrest, and I was missing my client's own statement. The car crash, I just received evidence on that, Your Honor, and the evidence will reflect that no identification was made of Mr. Dates. Defense counsel has one CCTV video that shows an obscured view of a man difficult to identify, a woman whose face is unclear, and a black SUV. One complete body camera. Out of all of the officers on the witness list, they were required to submit complete body cameras. That's a requirement of their policy and a requirement of the Constitution. All of the other videos were edited. The video that they're hanging their hat on, Isis Terrell, the only person in this case who can identify LeVon Dates, was completely black with no audio. I brought this up in the bond argument, and I wrote Ms. Major a very long email detailing the pieces of evidence I was missing. I was sent back a link I could not open. Then I was sent back a link with the exact same discovery that they had already given me. I reported that to her. This is exactly what you've already given me. This is what I'm still missing. She sent me another link. She represented that discovery link had all of the items I had requested that I was missing. It had none of the items I requested that I was missing. She represented that it did. Nothing. I'm missing any and all information regarding pulse videos, regarding pulling still photos from the video. That's important. That is the only person who can identify LeVon Dates. The only thing that shows that LeVon Dates was there at this shooting would be if that photo, the one person lineup, came from the video. I have nothing showing me that it came from the video. Nothing except for verbal representations made by prosecutors. prosecutor should not represent that they are fulfilling a defense attorney's discovery request, especially when those items are numbered and particularized, and there is no objection put forward to providing them, no more argument. Instead, the prosecutor sent the defense attorney the same items of discovery she already had and represented them falsely as being the items that were listed. The police investigation in this matter shows that they did not inform Ms. Ramona Hutchins of her rights. She's 17 years old. She cannot make a voluntary and knowing waiver. She cannot. She is putting herself in, it's a violation of her privilege against self-compelled incrimination. Defense counsel requested that she be advised of her rights by an attorney. Ms. Hutchins, in her statement to police where she did not identify Mr. Dates and was never shown a picture of Mr. Dates, Ms. Hutchins was told Ms. Hutchins was never told that she could potentially be charged with this crime. My investigator went ahead and interviewed Ms. Hutchins before she appeared. Ms. Hutchins kept asking my investigator for a picture because nobody had given her a picture. He did not provide one. When Ms. Hutchins testified, she was text messaging my investigator, and I have those text messages, stating that she was told by someone that talking to defense investigator was witness tampering, and that she screwed up. I have this in text messages. Her statement she gave to the police referred to cars exchanging fire during the shooting, and she referred to that in her testimony. Mr. Smith then should have been advised. There's a lot here.
So the premise of this is prosecutorial misconduct, which is
And
very serious. It's very serious.
It is very
huge, and
serious.
it's multiple prosecutors you're throwing into this bag here.
I'm not
And
throwing
now-
anything into
Well,
it.
I don't
I'm
know that anybody really saw that as something derogative towards you. I mean, throwing into the mix, and that again is not derogative towards you either. So let's first just take a step back because we need to take any emotion out of this. I'm asking questions and making sure that this is appropriate. I'm not hearing any objection from prosecution. So obviously all of this is expected because we had an opportunity to review the motion. I haven't. And I wanted to get an understanding, but it sounds as though now we are getting deep into the weeds, and that's not meant as in a derogatory way. I'm just, I don't know how else to articulate my thoughts at this time about cases, things that perhaps I have not had an opportunity to hear anything about yet. And prosecution is,
That's what I meant.
I'm not sure that this is an appropriate time to hear some of these arguments, but Madam Prosecutor seems to be acquiescing to this because she hasn't stood up or, I'm trying to make sure I understand exactly where we're going here. The main thrust seems to be prosecutorial misconduct by Mr. Slusky, Ms. Morales-Smith, and I'm not sure if Ms. Byrne-Bailey.
I don't have evidence for Mr. Slusky. But I did, that's why I sort of made that statement. I did have to do research. This is all supposed to be taken in context when you're looking at this. And it is a lot to take in all at once. I think that's why if you were to read my motion and you were to grant it, the law says that we need an evidentiary hearing to suss out these issues.
And who might you want to be present at that evidentiary hearing?
Okay, well.
I'm not trying to be, again, the record should reflect. Anything that comes out of my mouth is not meant to be anything as other than me just trying to communicate and make a clear record. So let me reiterate that. I need to have an understanding.
This is complicated, yeah. This is complicated. It's unusual. I've never done this before. I've never seen this before. This is a very complicated.
And we're in the middle of an examination.
And I have to put it in writing, Your Honor. I have to put it in writing. The law requires I put it in writing.
Okay, and I understand, and I appreciate
Your Honor?
that.
Sorry, if I may. I'm sorry, the people have not objected because I thought she was just talking about her motion. There is tons of this that people would object to. It's specifically the prosecutorial misconduct, straight up. But I thought I was going to get a chance to reply.
You are, and I don't mean to necessarily, can we pass on this for a moment? Because I do need to get Mr. Quinn out of here. We're gonna get you back on the record in just a moment.
Thank you.
Recalling people versus, I believe, is it Little? Cedric Little, 200-60794. This is people versus Cedric Little. Defendant is charged with weapons, firearms, discharge in or out of building, count 2, weapons, felony firearm, appearance displays.
Good afternoon, Your Honor. Ren Bailey on behalf of the people, P84009.
Good afternoon, Judge Christopher Quinn, P69483, appearing on behalf of Mr. Little, who is also appearing in person
Please
today.
state your name, sir.
Cedric Little, Your Honor.
Okay, we're here today for an examination. As I was beginning to explain earlier, due to court congestion, we were not able to get to the examination. I know the prosecutor was prepared to proceed and had a complaining witness that was here. And we were at the point of selecting a new date. We were talking about July 22nd at 1:30, and the issue of bond was raised to the extent that the prosecutor was seeking to revoke the defendant's bond for items that were brought to the record. But my, again, concern was, has there been any violation of the no contact provision since the defendant was placed on a GPS tether? Because these instances were instances that we reviewed on May 26th. However, they may have now generated into reports that have actually been filed. I understand that. I have a fullness of that. But again, you're asking for the defendant's bond to be revoked?
Yes,
And the complaining witness is in the hallway?
she is not, Your Honor. My office attempted to contact her immediately and have been unsuccessful in doing so.
Okay, and I know she was here earlier and perhaps thought she was just going to get a new date. Mr. Little and Mr. Quinn, I'll give you an opportunity to respond, but this is very serious. You are faced with 2 felons.
Possibly
One is
3,
a
Your Honor. The people are intending on amending.
At
Well,
this
Judge-
point, 2
Judge-
felonies, a 10-year felony and a 2-year felony, which is incredibly serious. And I know whenever there's some level of familiarity between individuals that are being charged and those that have been allegedly affected by the charges, there's always a tendency to want to reach out. The same level of tension that may have existed to bring you here in the first place. This is nothing to joke around with or to tiptoe on the line with. Your freedom while the case is pending is at stake. Do you understand that, Mr. Little?
Yes, Your Honor.
You are to have absolutely no contact whatsoever. Again, I ask, has there been a violation since the defendant was placed on a GPS tether?
Your Honor, I haven't been able to get that information. The complaining witness has been unable for me to contact.
Well, she was here this morning.
She was, Your Honor. I didn't have the opportunity to speak with her specifically about since the 26th. However, no indications were made to my colleagues. But Your Honor, I still would ask the court to reconsider the seriousness and repetitive nature of these allegations and the violations that I've already brought before this court are serious and have put the complaining witness in immense fear of her life, Your Honor. Additionally, I believe that remanding Mr. Little until the preliminary examination would be in the best interest of providing safety to the complaining witness as well as to the public.
Can your complaining witness be here tomorrow?
Judge, if I may respond just briefly, Judge. I find it almost, it's disingenuous on the part of the prosecutor, and I'm gonna tell you why. Because this was already discussed. This was already anticipated by the court. The court took steps, took appropriate steps in this case. This is not new information. Mr. Little clearly understood what the court had said and had respected the court's decision. For him now to be put in peril again for something that he has already had a hearing about, I think it's just, it doesn't, it's like the prosecution is trying to make this seem like this is something new. They mentioned something from December of 2020. We were talking about that in May. That wasn't something that they just found out. Now, maybe a report. I don't know what their issue is in terms of getting reports from the police department. Granted, if they want to charge, they have all the power in the world to charge him for that. But as it relates right now to his bond judge, he's in compliance. And you know.
Can you make a phone call real quick?
To
Your complaining witness.
Your
Because
Honor.
without the complaining witness walking in, going under oath, saying certain representations, I have to have a basis.
Your Honor,
And
she
there
is,
has already been a hearing, as Mr. Quinn said,
Your Honor,
May 26th.
I would actually, her phone is not able to receive calls. At this moment, she has been unable to be reached today, or since this afternoon, and I cannot leave a message.
Judge, I just so I can bring this up, and I'm usually pretty laid back, but I can't be too laid back on it. The thing is this, they ran into this court when they thought that Mr. Little had violated his bond. There was a motion that was emailed to me pronto. And then to hear the prosecutor say, I didn't discuss this issue with her this morning, it doesn't match up. If it was a pressing issue, like when we came back in May, there was a motion on my email so quick, and we would set a hearing so quick, and it was boom, 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 boom. Now it's almost like an afterthought. You know, if that was the point, if that was so pressing of an issue, it seems like they would have brought that up before we even got to the any issue. I'm talking about before we even got here to the hearing. Why did they not bring a second motion notifying the court, hey, this is the second violation that's occurred, and we got some new information for you guys? That didn't happen here. This is just old news.
Madam Prosecutor.
Well, Your Honor, I believe that the people are able to reinstate prior motions for the amendment of bond.
But in order for me to make any movement on your request, it goes both ways. It really, I have to be right down the middle in terms of making decisions. So if there is something new for me to, the last time you brought this motion forward, I granted your request. And so for me to now revoke the bond, there has to be additional new information or additional information that's brought before me. That's the only responsible thing for me to do. So if you want to try to get her presence via Zoom or on the phone in the next 10 minutes, I'm here for it. Or then I need the complaining witness here tomorrow.
If I would just say as a courtesy, if you got new information, write it down in a motion and let me see what, I haven't even seen that police report. You know, I haven't seen any report. I haven't seen the text messages that they're referring to. I haven't seen anything.
Well, admittedly, these are not new, hold on.
But they're
admittedly, these are not new text messages.
My very point.
Madam Prosecutor already admitted that.
My very point, that's my very point, Judge. So if it's nothing new and nothing's changed, then why are we asking for this man to be locked up?
Well, that's my point. That's my question exactly.
Your Honor, first of all, this is not a secondary thought for me. I have been very concerned about this case. I've been doing diligent follow-up. But as Your Honor knows, and everyone in this court knows, I was on the record for an extended period of time this morning that prevented me from speaking with the complaining witness myself, first of all. Secondly, I don't have the ability to turn over police reports for an ongoing investigation. It is an ongoing investigation for all of these things that I'm discussing and talking about. I did provide all of the text messages, and when we were here last, I did request for his bond to be revoked.
My question to you is, based on your demand for his bond to be revoked, what new violations have occurred?
I don't have any new violations, Your Honor. I am resubmitting to the court my last request for bond revocation. The complaining witness, and if I could get a hold of her, she would tell you herself. She is terrified. The contact was ongoing from September through May, Your Honor, between when Mr. Little was arrested on this case initially, allowed out on bond, picked up another case which is making its way through my system. Another instance where he interacted with her after receiving a no contact order from this court, as well as being served with a personal protection order. Your Honor, at this time, I believe that it would be in the safety of the complaining witness, as well as the public, to revoke Mr. Little's bond, like I asked back in May.
Can your witness be here tomorrow?
Your Honor, I don't know, but I doubt it.
Judge, they have everything at their disposal. They're saying there's a new police report which is supposed to go through the system. Not only they're trying to get a bite of the apple now to lock them up, but then they might have a second bite of the apple. They have the mechanisms to do what they're choosing to do, but one thing they're lacking is evidence, new evidence. So without the new evidence, Judge, the prosecutor is simply abusing his power. If you got a police report, where's the warrant at? If you got new evidence, where's the evidence? But we're sitting here talking about something that has already been addressed.
Your Honor, as I stated, it is an ongoing investigation.
Hold on, if you're asking for me to revisit what was brought up before, I've had I don't remember the last case I did this morning. So if you would like to lay out on the record what you deem to have been all the violations that Mr. Little has done since September, that will need to be done. And then, Mr. Little, even though it's been addressed, it can be readdressed, and your bond could very well be revoked at the end of this.
They don't have their witness here, Judge. They don't even have their witness, and that was what the court ordered. The court ordered for them to have their witness here. This is being considered by this court. The court ordered them to bring their witness, and they're saying they can't get in contact with their witness.
The witness was here.
And then what I'm saying is my client's freedom is a priority. If this witness's safety and she's such in fear of her life and her life is in, where is she at? Because for her to be somewhere else while my client's safety is in jeopardy right now, it's not fair. It's not fair that she gets to read off a piece of paper and say that that's what that witness is saying, and my client is sitting here and has abided by everything this court has ordered. It's not fair.
Well, Your Honor, obviously that's not true, because I have brought a motion. This is the first motion. This is what I'm asking the court to reconsider. A photograph of Mr. Little with a gun in December. Phone calls from May 9th. Your Honor, nonstop, with the last court date being May 26th. You're gonna get it, bitch, watch. A matter of time, let's see something come out of that grade.
Hearsay.
Your Honor, it's a bond motion.
Do
The
you
rules of
have-
evidence don't apply.
Ms. Barnes, that you can have Zoom in or appear here.
No, not today and not
No
tomorrow.
mode of communication at all for
Your Honor, if she's turned off her phone, how am I supposed to
How do you know
contact her? Because my colleagues and I have called her, and it's not going through. And there is no ability to leave a voicemail.
You have no other source of contact for Ms. Barnes.
At this point, Your Honor, no.
Well, we need Ms. Barnes on the record. That is important.
For a second time. She was on the record the last time via Zoom.
Your Honor, might I have the time to send an officer to go get her?
Sure.
Although I believe the court did indicate that it had a hard stopping time of 3:15. Given that it is 2:40, I don't know the efficacy of being able to get her here before 3:15.
And Judge, I know you have the discretion. I know you have total discretion with this, but I'm just asking, and we've gone over this. Without new evidence, it's not like we don't know whether or not Mr. Little has heard what this court has said. We know that because we know from May until today, there has been no issue. We know that. We know that. No, you haven't presented anything. So we know that. So what we're doing is saying, okay, even though you've proven to this court that you hear me loud and clear, let's listen to what may have, what possibly have, because there's been no charges brought. Granted, there's a report, but there's been no charges. Judge, I'm not trying to beat a dead horse, but I'm just saying.
I need you here tomorrow. I need Miss Barnes here tomorrow. I need you here tomorrow at 9:30. Mr. Little, I need you here. I need the prosecutor here. I need Miss Barnes here at 9:30. We're gonna call the case. An officer can find, if the officer can give her a ride here to the courthouse, just as you proposed an officer could have gotten here today. She needs to be here for an examination. At which time, after the exam is done, the court will consider any motions you'd like to make regarding bond. I need Ms. Barnes here. Okay, 9:30 in the morning. Mr. Little, I would really, really be careful between now and 9:30. I know that's a little bit of time, and sometimes people get real excited, real angry, real anxious. It will not be a pretty picture for you if your temptation to reach out gets the best of you. I don't know how more clear I can make that. But if you thought you were concerned about your freedom right now, watch and see. I think you would be playing with fire. There is to be absolutely no contact. If your tether starts to beep out of the area for which you should be, there's gonna be a problem. You are not permitted, in fact, to go anywhere except for work. That's according to the order that I prepared. You are not to be anywhere near the complaining witness's residence or family. Reach out by telephone, text, social media, or have friends reach out to the complaining witness. Do you understand?
Yes, ma'am. It's gotta be 9:45.
9:45. Ms. Bailey, just as an officer you were proposing could have brought her here this afternoon, I need someone to procure her presence. Maybe take a little visit to her this evening and make sure that she is aware. I don't know how one gets in touch with their witness if the phone is off, but it would have been essential, I would think, to have some mode for which to communicate with the complaining witness. 9:45 tomorrow morning. The GPS tether is still in place. However, before we break from the record, I want you to go into the hallway and see if you can call one more time. Even if you just get her on the phone.
Well, dates or Mr. Slusky's
Mr. Slusky, are you available?
I am, Your Honor.
Where's she at? Miss Slusky's
Right here.
Calling parties on. Dates, case number 2158343, the people of the state of Michigan versus Levon Terrence Dates. The defendant is charged with count 1, stolen property, receiving and concealing motor vehicle. This is scheduled for probable cause conference.
Name for appearances, please.
Good morning, Your Honor. Jacob Slosky on behalf of the people, P83677, and this is for the case ending in 4301.
Good morning, afternoon. Nicole Sade is still present, still appearing on behalf of Mr. Gates, who's also still present.
Please state your name.
P74238. So the last time we were here, Mr. Slosky said I had received a lot of discovery from him, I think 21 pieces of video, plus a report. I think he stated that he had 2 more pieces to send to me that I haven't received.
Ms. Sadie, I just sent them. You should receive them shortly. And they were 2 additional videos, body cam evidence, interviewing the complaining witness and witnesses at the scene. I had to edit out videos of driver's licenses, victims' phone numbers, etc. So that it has been redacted and you should receive it shortly.
Okay, I do need enough information so my investigator can interview your lay witnesses. I'll communicate with you. We email, so I'll let you know whenever you.
Sorry, I had trouble hearing all of what you said. Could you repeat that?
If you recall, last time I asked for the phone numbers because I want my investigator to interview the lay witnesses.
Okay, I'm not going to disclose the phone numbers of the witnesses, but if you want to discuss making them available, then we could certainly have that conversation.
Oh, you have to make them available, so we will. I have to review this video evidence and I have to talk to my investigator to see what she needs. If there's any additional information she needs beyond to properly prepare. Mr. Dates is currently incarcerated. If you could give me an exam date that's at least 2 or 3 weeks away so that Mr. Slosky and I can figure out whether or not I have enough information to give him effective assistance of counsel. I'd appreciate it.
Response?
I'm sorry, Your Honor.
Okay, you need a new PCC date? Did we set a PCC date on the other matter?
For July.
July
Yes, Your Honor.
25th?
That was an
July
exam.
21st.
Oh, that's correct. That's correct, yes.
Okay, new PCC, July 21st at 8:30.
That works for me. I just want to be clear. Were you expecting me to respond to something, Your Honor?
No.
No, I'll email you. I'll talk to my investigator. If she needs more information, I'll email you and let you know, and we'll work it out.
Okay, sounds good.
Thank you.
Was on top of your chair, it'll stop falling off. Because the chair is closing down. And if you put this on top of your hand, it kind of moves with it. That's why. Because it was off when it was on, you could tell.
Where are we? I guess back on the original dates. I think you still have that file.
The original dates, yeah, I do still have that. Okay.
Oh, she's there, but she's just.
I meant the other one.
Oh, okay.
Recalling people versus Levon dates. 210-57575. Appearances again, please.
Lauren Merle Smith for the people, P 83353, Your Honor.
Nicole Said, P74238, for Mr. Dates, still present.
Mr. Dates, please state your name.
Lamont Davis.
Did you want to continue on what you were saying?
Yeah, let me just say, Your Honor, I have a lot of cases too, and this one has a lot of information. When we were here, not the last time, but the time before, we went back and had a sidebar. And I sort of revealed the tip of the iceberg. And you asked me to file a motion. If it was a simple motion to dismiss, I would let the rest of the exam play out and make my oral motion based on the facts. I would not, certainly. The court is the decider, and evidentiary or hearing is the decider of whether or not there's enough evidence in my motion, what the weight is, the credibility. It would have to be confronted if you were to find that there's enough here to grant my motion, right? We'd have to have an evidentiary hearing on all of this evidence. I would not spend this much time putting something in writing via motion and via brief if I didn't think that there was some substance here that needed to be examined by the court. So this is a very sensitive topic. It's very unusual. I've never dealt with this in my career to date in this way, and I've had to learn a lot. So I was expecting the court today to rule on whether or not we have an evidentiary hearing. So while I know the material and I know all the facts here, I'm not prepared to put forward a really polished, well-versed oral statement as much as, I'd like to indulge the court. I'm afraid that because I haven't mentally organized all this information in my head, I'll make misstatements, I'll miss things. So I'm just gonna ask to basically rest on the brief, even though you haven't read it yet, or to indulge me and give me another day so that it's just a lot of information that I find unusual, that I have to get my arms around to get out of my mouth, right? Instead of
I understand that, and I want to give you that opportunity. I don't want you to feel rushed or to feel as though you should be proceeding when you would like to gather your thoughts in a more organized fashion. I do recognize, I do see that you put the time into the motion, which I would like an opportunity, if you could leave me that hard copy.
Yes.
And I'm trying to be sensitive to the fact that your client is in custody. That challenged against the fact that we don't really have a whole lot of free time with our docket, but is there, Tammy, any magical date for which someone has perhaps canceled an examination this week?
That's what we use, 7/22.
The 22, that's okay. I'm sorry, before I forget, I had requested an order for the investigator. I brought a proposed one for you to review.
And what is that again?
Investigator Edwards, who's on all three cases, allowing her access to visit him in person.
Oh, right, yes, yeah, please make sure you present that. But the overarching point that you're trying to request here is an evidentiary hearing wherein you're going to call witnesses as it relates to what you believe amounts to prosecutorial misconduct?
Correct.
And those witnesses would be comprised of officers or?
Correct.
And do you think that in the middle of the examination is the most appropriate time?
That's your discretion. I'll leave it to your discretion. I put the motion and brief in the court order to stay if you would like to, hold it in abeyance. That's in the court's discretion. I'm not gonna.
Well, I guess I'm concerned that we're arguing this in the middle of the examination as opposed to, and before I say it, I know I'm thinking of how you're going to respond. I was going to say, as opposed to before the exam, which I know you're saying that there are certain things that have come to light in a sequence in which that was not possible. But I'm just saying, in the traditional sense, that there would be a hearing of this nature either before or after at a later stage in these proceedings. I think it's a little out of the norm for the court to be addressing a motion of this stature in the middle of an examination. Let me just ask, for the sake of asking, was the prosecution prepared to pick up with this examination here today?
Yes, ma'am. People are prepared to continue with their examination.
With the presentation of?
There's a motion to strike because one of the complainant is not present here today.
Who is the complainant?
Mr. Andre Smith, if you recall.
Okay.
So the people were going to ask for the motion to strike his testimony, as the defense never got a chance to cross-examine, and then we were going to start with Detective Eric Hartman.
And then who else were you planning on presenting for your proofs?
No further people at this time, Your Honor.
Actually, that case is coming tomorrow, so July 22nd, afternoon, July 22nd is still.
Wait, but I thought we.
We were
Oh,
gonna put
right,
Mr. Quinn's
right.
line in there, but we're doing that tomorrow. so
Right.
July 22nd is open
Okay, so
in the afternoon.
thank you, Madam Clerk, you're right.
Your Honor, if I may, I would like, one, a chance to respond to the things said thus far. Plus, Your Honor, I'm not sure who is being accused of prosecutorial misconduct, if that is myself, if that's Ms. Najor, or who exactly is the charge being.
I would imagine.
Actually, it's very clear. It's very clear in my motion, and in your response, it seems like you understand that it's very clear as well.
Well, and if we need to get Ms. Najor available, she no longer works for the prosecutor's office.
Okay, well, Ms. Sadi did spend a lot of time putting that motion together, and if you haven't had a chance to go through it with a fine-tooth comb, this will afford an opportunity for not only the court to read it, but for you to review it as well. But I'm assuming you did, because you did provide a response.
Yes, Your Honor.
It is important for the court to review it, although again, I'm going to emphasize that it appears to me, my knee-jerk reaction is that the timing of this might be premature to hear the motion in the middle of the examination, of a held in part examination.
May I just, since we're talking, may I ask, are you still presenting Isis Terrell?
Not at this time.
Oh, not at all, or not today?
We're definitely not presenting her today. We may present her in the future, but we are not presenting her today.
Is that, okay.
As far as the examination is concerned, we are not presenting her, Your Honor.
Okay. Is that someone that you expected that was to be presented with?
I did. It's the only person that identified Mr. Gates. And like I was saying earlier, there's an issue as to the Warren Code lineup.
Okay, so I don't want to shortchange your arguments. I am going to, if you could leave me with the hard copy, I'm going to read the motion, and that will give us an opportunity to deal with it, either by way of ruling or granting your request that's being made. But either way, if you're available on July 22nd at 1:30, that's really the only date we have available to pick up. And the expectation should be that any leftover witnesses need to be there and be prepared to be presented if your intention is to call them.
Understood, Your Honor. I guess my question as to who the charges are, the prosecutorial misconduct are about, because it's only addressed to me. So if it is only me, I understand, but I believe I've heard Ms. Najora's name in here several times. But
Her emails with me and her emails are attached.
She's answering.
I'm sorry.
She's trying to answer your question.
the motion is only addressed to me. So if it is to include Ms. Najora, then there should have been Ms. Najora's name on this as well.
I understand now. I apologize. I misunderstood you previously. It is, and I will make objection.
Okay, so July 22nd at 1:30.
All right, okay. That works for me then.
And please, just if you could, I know I keep reminding you, but if I could get that hard copy from you so that I'm prepared when we come back. That leaves us with Mr. Quinn's matter.
And I'm sorry, that was July 22nd at 1:30.
At 1:30.
Thank you.
The top one is the order. Okay.
Ms. Haydar?
Yes, hi, Judge.
Hi.
I'm going home. I'm seriously going home.
Do you have someone for me?
I have a witness that was picked up on a material witness detainer that you signed last week. I spoke with Ms. Tammy Jones a little bit about it. I'm just checking in to see if there's any way that you would be able to hear that matter quickly, maybe after this exam, or I am sure I know the court has a hard stop at some point.
Can you use that?
He's in police custody, correct?
Yes, and he had just
tomorrow, right?
One more time.
And this is a matter scheduled for exam tomorrow, right?
Yes, Judge. Tomorrow at 10 a.m.
Are you going to ask me to release the witness detainer?
Well, I was going to ask for a GPS tether on him at the very least.
The exam's tomorrow, right?
Yes, Judge.
I mean, the typical fashion would be that we would take that up on the date of the exam, right?
Right, because even if you ordered a tether, he's still gonna be in custody tomorrow. They're not gonna put a tether and release him today.
That's fine. I just wanted to check in just to make sure that something was being done and that he wasn't just going to be like left like unattended. I guess that was pretty much it.
They're gonna hold him in custody until he testifies.
Okay. Thank you.
Okay, thank you.
Okay, I don't know either. You gotta tell me what's going on.
Okay, he's a detainee witness, so he's just gonna be held in custody until tomorrow when the exam is scheduled.
Right. I don't really know either. We just spoke with her, so you should be all set. He's in custody, right? Yeah, we don't need him here today. The exam is scheduled for tomorrow at 10 a.m. So I guess he goes to DDC and then they'll bring him over tomorrow to testify. I don't know. I just always know when we have detainee witnesses, they come through our back door because they've been in lockup. And how they get there and all the ins and outs, I don't really know. Yeah, okay, all right.
Okay, so, I mean, you're funny.
It's too late in the day for this stuff.
Now what is this? This is just, oh, okay. We're back on the record. In the matter, hold on 1 second, let me put this date aside though. We set that for July 22nd. Any update? Okay, we're back on the record in the matter of People versus Little. Appearances again, please.
Bryn Bailey, on behalf of the people, P84009.
Good afternoon, Judge. Christopher Quinn, P6943, appearing on behalf of Mr. Little, who's also appearing in person today.
Please state your name. Please state it one more time. Thank you. Okay, do we have any sort of an update?
Your Honor.
Any
any morsel of information that might be new?
Your Honor, I have called the complaining witness. The number that I have for her in my physical file was unable to get through. I called the victim advocate, left a voicemail for him. He is not in the office, Your Honor. And I have not been able to call the officer in charge with success at this point.
What do you propose we do at this juncture?
Your Honor, I'm gonna try the officer in charge again. Once court is over, to see if I can have him stop by the complaining witness's residence and perhaps bring her to court tomorrow. If that is unsuccessful, Your Honor, I would be asking for an adjournment, given that the people were prepared to proceed today. And through no fault of the people's or Mr. Little, we were unable to proceed with today's date, Your Honor. I believe not something similar. I don't recall what happened on the 26th and why we were unable to proceed via Zoom. But the complaining witness, Your Honor, has been here repeatedly. And if my attempts to contact her before tomorrow are unsuccessful, I would ask for a new date and a witness detainer.
He will be telling witness, so he's got to go into lockup until tomorrow when they'll bring him up to testify.
Mr. Glenn?
Judge, I have no issue with holding the exam. That's what Mr. Little wants. He wants it in person. If that's tomorrow, that's tomorrow. I just maintain my objection to any modification of bond at this time.
Okay, can I speak to both attorneys in the hallway?
She talked to the judge. The judge said I ran people. If that was the case, no, it's not. If he was gonna come on his own, they would have needed to do it. I would have. So he was gonna be working custody overnight, and they're gonna bring him over to my house. And then it's really or then they say, we're gonna dismiss this case, or we need them to come back the next day, so we're gonna set the bond and put him on the test. We don't, none of that happens right now. So he just needs to go back to BDC and then bring him back over here tomorrow. You know, I don't know, everybody else already knows how to do it. I think they need to walk through here. I know it. Oh, okay. Well, they're just listening to this. It's not the process. I mean, if you're gonna give him a personal bond, then he would have just came in on his own to testify without. Anyway, let's go home. Let's go right now. Bye. I don't even know. Well, speaking of, we're still being taped. I was in trouble being taped. Did you happen to jot down, well, I need to know what his bond conditions are.
What?
Mr. Dates' bond conditions. I have a date.
Date?
Yeah, so we schedule that for the 21st. For the probable cause, yeah.
Yeah.
For
It's
two
good, yeah.
PCCs. I can do that without the file. She still has to file it there. I don't have to file.
Oh.
And then the other attorney, Madam Defense is still waiting on that. I told her she had to wait till you get done with the order.
I don't even know what you're talking about.
The case with the last judge, Bates, what's his name, Bates?
What does she want from me?
She's waiting on a copy, I guess, from the order she submitted,
The motion?
the motion. What you want me to tell her?
I don't know what she's talking about. If it's something the judge has to sign, I can't give her anything until the judge signs it. If it's something else.
I thought that the judge is having 5 marks.
She kept saying, she's up there. I thought, oh, they're doing something else. But if it's a signed copy, I can just scan that, email that to her.
I can't give it to her until the judge signs it. And I've got other things going myself too.
I'll tell her if you email.
Now, if she's waiting on a hard copy or something, I thought she was giving that copy to the judge.
Hold on, let me sign it.
They gonna make me lose my mind.
On what?
Up in here,
I
up
gave
in
you one.
here.
I'm doing the other one, but then we still have the held in part thing. I'm not sure what the schedule, she still has the file.
Oh.
Hey, Tammy, you realize you're recording the words to a song?
Yeah, I did. Do what?
It's for the order for her investigator to visit her client in jail.
Oh,
The
yeah.
judge is in the hallway.
I told her that.
She may not get that till tomorrow. I will scan it and email it to her. If she wants to wait, I'm here till 4:30. I can't make no promises. I just don't know, I can get the dates, but I don't know what his bond conditions are. Do you have a copy of his last order?
You got me, oh. Which case is that?
The one with Slusky, the, car theft thing.
Just email it to her, Tammy.
8343 case.
Yeah,
Yeah, they,
I don't think there's anything on it. It's a, I think he's got,
ain't giving no paperwork on that.
all right, no, we're just gonna go put the date on there. I don't think it, that's not like he would have like no contact or anything.
One of the PCC case.
So she. I told her.
Yeah, I mean, it's all still up there, so she, you know, she just don't do it just like that.
Yeah.
I'll send it to you tomorrow. I mean, when y'all done detainees, they bring them over from the jail, right? The reason you're a detainee is because you were refusing to come in on your own to testify.
Correct.
So what sense does it make to have that young man come in here and for the judge to give him a personal bond and release him and expect he's gonna show up tomorrow to testify?
Just keep him as a detainee till he show up.
If he was gonna do that, you wouldn't need a detainee.
Exactly.
You would need a detainer. He's just gonna come in on his own.
Usually they bring them in.
They bring him in the bag.
And put a bond on.
Right, after the fact. Right.
Things have done so different, or not consistent.
I just think that there's too many new people who don't really know. And instead of. Yeah, he has to get an attorney appointed, but I do all that after they're here. Not before. I can't call right now and get someone appointed. Where's he gonna do it to? How are you gonna talk to him?
He's not. I've been in here with you. We ain't got no
Where's
one
the
else.
other one? Now, what day did she get the health department?
November 22nd, the next day.
Next day, at what time? 1:30?
1:30.
You never know.
So just keep coming up.
Crazy stuff just popping up. Cindy, I emailed you those, that paperwork you need on that exam you did. She's got her ears on. So did they schedule that for an exam or for a motion hearing? Because it doesn't sound like we're going to an exam.
For which one?
For that date one with Miss Sadi and Miss Morales Smith.
I'm not sure.
I'm not
She
sure.
wanna go ahead with the exam.
You
And
know,
hold the
Sandy.
motion in the baby.
Oh, no, what's that?
Oh, okay.
That's what I thought.
Okay. I'll
Could be
check.
wrong.
I'll double check with her, and I'll have it for you in just a second, as soon as she comes back
No, woman is asking, is that next date, was that jail or date? Was that an examination or a motion hearing?
No, I had to go through.
here. That's okay, I'll ask the judge when she comes back out.
Okay.
There's too much going on.
And your patience person is priceless.
Me, you know what, when we get to finally take these masks off, I'm gonna be in trouble. I will sure be in
I'll
trouble.
be cracking when somebody says something every once in a while. I hear you too. I'll be like,
Oh, when she be up there again.
yeah.
Where's that all right now? Leave it so we can chat. Yeah, I'll be in trouble. Even at the store, people get in my way, and I'm like.
Right.
So I don't leave behind my mask. Somebody probably caught me one day.
Okay, so we're back on the record in the matter of People versus Little, Cedric Little, and had an opportunity to speak with both prosecution and the defense. The question right now, we are going to hear this exam tomorrow at 9:45. Tomorrow at 9:45, July 7th at 9:45 in the morning. It is my expectation that every effort will be made to not only contact the complaining witness, but, well, Madam Prosecutor had indicated perhaps someone could go to her residence. I want every effort to be exhausted as it relates to that due to the short turnaround notice, and the implications at this time that have been presented before the court. Prosecution wants the court to reconsider the bond and to revoke the defendant's bond. And I am going to allow a brief dialogue, but only brief, because the court is going to close the record in this in just a moment. But, well, and really, I'm not really opening it up to further argument because I heard everything. And the bottom line that the court is hearing from the prosecution is that since the court acted in May by adding a tether to Mr. Little's bond with the restriction that he only be permitted to go to work, I'm assuming that has been abided by.
Yes.
And that is going to remain in place. Since that date, no new allegations of violations have occurred. Again, that is my understanding, and if that is incorrect, then I will reconsider the action I'm getting ready to take. But the action that I'm going to take is to deny the motion to revoke your bond. However, that decision is not made lightly. And Mr. Little, it is, I explained to you shortly, not long ago, that it is really important that you understand the significance of the predicament that you're in with these charges alone, let alone the possibility of any violation that might occur. This is your life. And it is really important that you do whatever you need to do to safeguard your bond. And that would include not straddling the line here and making sure you have absolutely no contact with the complaining witness in this matter. Again, Madam Prosecutor, have there been any new violations since May 26th?
Not that have been disclosed to me, Your Honor. I would just, again, reiterate that I'm requesting the revocation because I do not believe that GPS tether alone is sufficient to guarantee the safety of the complaining.
I believe the court has framed the issue. Obviously, it's made very clear, not only today, but as well as back in May when we were addressing these issues, what was expected of Mr. Little. I believe Mr. Little has taken that seriously, has taken that to heart, understands that he's on a very thin line and he has a lot to lose.
Well, hold on. What makes the prosecutor take that position? Because what this court doesn't do is take lightly what's going on here. If there is something for which the prosecutor is aware of that the court is not aware of, some alleged violations beyond May 26th that have occurred, then the court is going to revoke the bond. If there is some continued violation that is occurring, if you are doing anything, Mr. Little, to threaten, intimidate, or even just be present around with the complaining witness, the court is prepared to revoke the bond. The prosecution cannot just say that revocation is something that I want and I think it's appropriate because otherwise the complaining witness, her safety is in jeopardy, without providing more substance. And when you put that statement out there, it makes me believe that there is something that the court is not aware of.
Your Honor, just everything that I have already submitted in my motion back in May, which again, I'm just reinstating at this point. Because like in May, I now still, my position on revocation of bond has not changed since May. But no, nothing new as far as I am aware since the addition of tether.
Is the defendant allegedly still contacting the complaining witness? Is he doing anything of a threatening nature to the complaining witness?
I have no information post-May.
Mr.
I believe that it's clear that Mr. Little at this point, once the court made clear what it expected, put the restrictions on Mr. Little, he's abided, he's working, and he's ready to defend himself against these allegations, Judge. And I believe at this point, the bond is appropriate.
Okay, we're going to see you, Mr. Quinn, and your client, Mr. Little, tomorrow at 9:45. I would plan to get here in advance of that hour. We are going to put this case, Madam Clerk, as priority and call it at 9:45. If the parties are ready in advance of 9:45, we'll call it at in advance of 9:45. Matter is set for an examination tomorrow.
Okay, thank you.
What were you all saying?